Supplemental list, fresh submission item number 1.
Below, the opposite party number 4 is a contractor encroaching the government plot below, and that plot is in front of our. And we have given the representations annexure 1 running till 7 below, and also a online.
The petitioner's representations shall be examined by Tahsildar Bujanda, and after notice to the petitioner and opposite party number 4 and giving them a hearing, a reasoned order shall be passed not later than 15 July and be communicated to the parties within a week thereafter. That's
Item number 2.
similar matters.
As per the information received, the loan account is already settled.
Counsel, the appellate states that the loan account has already been settled. The appeal is disposed of as having become infructuous.
Item number 3.
But the petitioner filed this application for he has applied to the Tahsildar for eviction of the OP number 5, who has unauthorized occupation of the government land and also the passage of the water passage, for which the petitioner
And the petitioner's representations, bracket annexure 2 series, shall be examined with the Tahsildar Dharamsala, and after notice to the petitioner and opposite party number 5 and giving them a hearing, the reasoned order shall be passed not later than 15 July, be communicated to the parties within a week thereafter.
Item number 4.
Some defects are there. They remove the defect.
Alright. Petitioner's representation, bracket annexure 2, will be examined by
This matter already personal Lakshmi direction. This is second round litigation. Personal Lakshmi direction where the collector called me. I presented with the collector, and the hearing was started, but no result has been published. That is the Lakshmi, the physical handicap person. Some lands have been acquired by him, and he wanted to that should be given to him because this I am annexed some persons blood. They have enclosed the government land, they are general category persons. But if he is a physical handicap persons, his case has not been considered. That will also be directed to consumer representation. I went the collector called me. I went there. I felt the trial blood, but there was no result published. That is a
Direct the collector to pass final
final
order.
order. Yes,
that is said that pursuant to the order passed with this court on 19 September 2022 in writ petition civil 21659 of 2022, a notice was received from the deputy collector by the petitioner on 26th October 2022, asking the petitioner to appear before the collector on 19 November 2022 for hearing. Stop. Counsel for the petitioner states the petitioner did appear and place all his documents, but till date, no decision has been communicated. Paragraph. The direction is issued to the collector to strictly comply with the earlier direction issued by this court. Where is that order?
This is the order blood. I've got also mentioned in it.
On 19 September 2022, and after giving a hearing to the petitioner as well as opposite party numbers 5 to 19, how come that is before the single judge? No. In your thing, you have said 19 September. In your writ petition?
Order is not annexed.
No, order is not annexed. I'm not
You should
annexed.
have annexed that order.
But I mentioned in the body that.
Where is that? You have said 19 September.
But
And some other number you have given, para 11, come to para 11.
or 11. Is giving showing some other order, sir. But WPC number 2165.
What you have shown us is something else. This is a Karunakar Sahu matter.
Three judgments.
order the donor.
Just a minute.
Before that order.
Judgment is not with me, but that I mentioned. I mentioned para
No,
11.
but where is that? You mentioned, I want to see that order.
Yes, sir. Yes, that the judgment is not with me. Three cases are at a time were filed.
It's 19 September, it says. See this. 21659 of 20.
But in Anisha 3, the Lordship's court orders mentioned blood. Two ones.
And how is it some matters are before the single judge, some are coming here? What is your system on
Because
which?
this matter could have been before Honorable Justice P.R. Sarangi when he was sitting single and taking this type of cases, encroachment matters.
That now it is should be the division bench blood. That is why.
How is it suddenly before the division bench then? On what basis do they allocate matters? How is this before the division bench, sir?
Because it is nomenclature as
Oh, Justice Sarangi has sent it here.
Yes, sir.
Nomenclature
Yes,
as?
PIL bench. Justice Sarangi has placed.
Not a PIL matter.
It's not a PL matter. It's personal.
You say this is not a PIL matter. In fact, the petitioner's own earlier writ petition, 21659 of 2022, was disposed of by the single judge on 19 September 2022. So, placed before the roster bench of the learned single judge on 15th May. All right.
Item number 5.
May I please? Similar matter, my lord, single bench matter. Similar, my lord, single bench matter, refer to your lordships, not PIL.
Yeah, this is not a PIL matter at all. Stop.
Put up before the single bench, my lord.
List before the roster bench of the learned single judge. 15 September.
Obliged, my lord.
Item number 6.
Make results matter. 11 persons were encroached the canal due to the water was not flowing in that area and agriculture fully were affected. For that, previously the petitioner came to this honorable court and honorable court directed to eviction proceedings should be started, but it was again inquired the matter and they have said there is no encroachment. As per unnecessary 1 mile, 11 persons were encroached. It was reported by the Tahsildar Danapur, but in unnecessary 10, there is no encroachment. For that, I pray to your lordship, this matter may be referred to CBI.
CPI.
Where is the person? CBI, sir. What is all this? What is the crime? Why should CBI come into it?
The two reports are not similar. Now the agricultural land are not taking water from by the canal. Canal land are.
How is the CBI coming into this? What is this for the CBI?
And the officers are supporting to that encroachment persons.
Just supporting is neither here nor there, sir.
The
Why is it the CBI?
The Tahsildar and the for that.
If you want to go to the Lokayukta, if you're making specific allegations against public servants, you have to go to the Lokayukta.
Previously, my lord was already directed to enter the matter and take it.
Where is that order?
Where is that order? 25, page 25. and some 9, my lord.
Illegal encroachers, all right. So they say you are the encroacher.
My lord, para 6, my lord. Para 6, page 28. Considering submission made and keeping in view the agreements stated in paragraph 11 and 12 of 13 of the counter affidavit filed by the opposite party number 2 and 3, which are quoted above, we direct the executive officer Banapur NSC for the opposite party number 5 to initiate the eviction proceeding against the unauthorized encroachments in accordance with law and complete the same within 4 months from the date of receipt of certified copy of the order and place the compliance report before this court. The collector and the superintendent of police Khordha are directed to extend necessary support and security for aforesaid eviction drive, my lord. But they inquired the matter and they said there is no encroachment and no proceeding, and I have filed due to non-compliance of this order. I have filed the contempt petition. Contempt petition was dropped, my lord.
Then it is dropped.
Then what it means? As per report of the Tahsildar, my lord.
Yes. Yes.
Correct. When previously, your lordship, you can say unnecessary one. That Tahsildar has given that report, my lord. So now they did a proper inquiry. They dropped 15. Your lordship can see 15. Page 15. Unnecessary one.
Yes.
This is the report of the Tahsildar.
Right.
The report by
Yes.
these household, these 11 persons were increased the normal land. These households are depositing garbage of the house in the river Satwa. Even pipes have
2013, sir.
This is the old report.
2022, they have found
the intentional to proper inquiry.
have another.
That contempt is dropped.
Yeah.
And there, according to him, there is variance in 2 reports, 2013 and 22. So that is a development in between.
There is no development. We are fully inquiry. Only commission will to inquire the matter.
Bring matters to a close, sir. This is the second round of litigation brought forth by the present petitioners. Earlier, they had filed writ petition civil 16636 of 2018, which came to be disposed of by the division bench of this court on 10/12/2019, asking the executive officer Banpur NAC to initiate eviction proceedings against unauthorized encroachments. Paragraph. Pursuant thereto, a compliance report was submitted by the Tahsildar Banpur. A survey report was submitted by the Tahsildar Banpur on 19th January 2022 to the executive officer Banpur NAC. On detecting unauthorized encroachments over Salia River near Chun Kasahi village. Paragraph. This in turn was based on a report of that date of the revenue inspector Banpur. Paragraph. Unhappy with the above result, it appears that the petitioner had filed a contempt petition. Stop. Counsel for the petitioner states that the contempt proceedings were in fact dropped by this court. Stop. Contempt petition 1017 of 2021, which was disposed of on 31st January 2022. Full stop. What is this 8553 of 2023? Oh, you did not make the encroachers a party. The petitioner then filed writ petition civil 8553 of 2023 in this court, without making any of the encroachers parties, and therefore the petition was permitted to be withdrawn on 5th April 2023, paragraph. Now the petition has come forth with the present petition, praying that the matter should be referred to the CBI. Paragraph. The basis for this plea is that way back on 20th February 2013, the Tahsildar Banpur had given a report in which he purportedly named opposite parties 6 to 16 herein as encroachers, whereas the subsequent report submitted on 19 January 2022 says to the contrary. Paragraph. There is no, as far as the court can see, there is no occasion to refer the matter to the CBI at all, as there is no at all, full stop. The report dated 19 January 2022 was submitted by the Tahsildar Banpur, was obviously accepted by this court, which is why by the order dated 31st January 2022, contempt civil number 1017 of 2021 was closed. Consequently, full stop, in the above circumstances, the petitioner cannot be permitted to re-agitate the matter again and again. Stop. The writ petition is accordingly dismissed.
Item number 7.
Item 7, my lord, the Mr. Raiguri is there. It is a old matter. SR could not be removed. Can it be given 10 days time to remove the effect as well as built up the records? Because with 2009 it was.
It was a 9 matter, no way.
But we have collected the record from the previous council.
No,
Mr. Raiguri is there.
No,
Please, your lordship.
it's all right.
My lord, I am submitting. I am submitting. Item 7. The deceased father of the petitioner enrolled under the army on 559.
Not filed a certified copy of the impugned order for the last 14 years, sir.
Yes, my lord.
That defect is not cured.
Your lordship will dispose of this matter.
All right.
Yes, my lord, I am submitting. My submission may be taken into account. What is the problem in this case, my lord? The deceased father of the respondent enrolled in the army on 5/5/1943 and he was discharged from his service on 5/9/1946. But after the death of the father of the respondent, her mother was getting family pension with effect from 22/9/1997 till 31st/12/1995 at the rate of 60 rupees per month. Thereafter, my lord, on 1/1/1996 up to 91, he was getting his family pension. But after the death of the mother of the respondent, the respondent was sanctioned with all the death benefits areas in his favor. But after the death, my lord,
Prepared to answer some question?
yes, my lord.
What is the date of the impugned order?
Impugned order, my lord, 27/8/2009.
And today we are in?
23, my lord.
How many years have gone by?
14 years.
Have you complied with the order?
Well, actually, what is the problem, my lord?
The problem is several problems may be there.
Yes, my lord.
In these 14 years, have you paid pension?
No, what is that problem I am explaining, your lordship. What is the problem in this case?
We will tell you what our problem is.
I am not stand on the way of the respondent, my lord.
What is stand in the way?
Yes, my lord.
You answer the question. In the last 14 years, have you paid pension?
For 14 years, my lord, he is not eligible. He is eligible till 2000.
So 14 years, despite an order in his favor, he is not eligible. Was there a stay granted by this court?
That was challenged.
So mere challenge means stay.
No, my lord.
You file a writ appeal in 2009, don't cure defects of 14 years.
That is why I pray
You deposit with simple interest at 6%, you deposit the entire pension here. We will then consider
what he is interviewing.
Mr. Paddy,
Well,
Kindly deposit the entire pension amount. You calculate the entire pension amount in terms of the judgment of the next single judge. Together with 6% simple interest, you deposit it in this court. Then you will consider it.
But he is entitled. I am not valuing that.
Sir.
One thing.
This is not the
really listening to me.
I will. You are not listening to us.
Yeah, I am listening.
You just stay quiet. I am asking Mr. Paddy something.
My lord, what I am praying, my lord.
Yes.
Today I received the copy from this files. We have not properly gone through. What Lordship is observing is absolutely correct. Suppose there is no interim order, definitely this active, the department should act upon. It is, I am conceding, my lord, before my lord. But this problem is that after the order of the Lord Tribunal, and it was challenged before this court, and this disputed things are before my lord. So Lordship may give 7 to 10 days time. In the meanwhile, we will sort out these things and we will apprise the court. Accordingly, we will file the affidavit and it can be listed to my lord.
All right.
This is my limited prayer before my lord.
All right.
My lord, may I pray?
Lordship may observe it. Lordship may say, Lordship may observe it.
10 minutes, no problem. You carry on, carry on.
What is the problem? I will explain. Then you Lordship pass appropriate.
All right. All right.
What is we are agree, he is eligible, quite eligible to get pension up to 2,000, my lord. And but what is the problem with us, my lord? Kindly have a glance to the corrigendum issued annexed in the counter, my lord. That is the whole problem, my lord. As the corrigendum has been issued by the department on the annexed B/3 at page 10 of the counter, my lord, there is a clause. Other entities including, madam, first time his claim was rejected. Therefore, as per the corrigendum issued, and we have a glance of the corrigendum, madam. As per the corrigendum, the ordinary family pension to the son will be admissible till he attains 25 years age or till the date of his marriage, whichever is earlier, madam. Thereafter, madam, he has got represented, he has represented in the year 2007 after 16 years, madam. Therefore, in the meanwhile, the corrigendum, madam, other clause 2, it has stipulated that other entities, including effective date, remain unchanged. However, past cases deciding otherwise on the basis of MOD letter dated 1998 will not be reopened. Will not be reopened. So, as per clause 2, my lord, the concerned officer did not reopen that issue regarding sanction of pension, but he is quite eligible to get pension since 1991 till 2000, as per the order of this honorable single judge, madam. Up to 2000 he is entitled to. But due to such clauses, the concerned authorities are not able to sanction him the therefore, we will also, and there was also recommendation. Madam, kindly have a glance to annexure page 12, madam. Page 12 of the writ petition, writ appeal. There is a recommendation in his favor to sanction, to consider his case, madam. But because in view of the corrigendum, that was earlier rejected, so they could not reopen his case, madam. That is the whole problem. If you lordship will pass order, then accordingly his pension will be released, madam. I am not stand on the as a bar releasing his pension, madam. But that is the problem due to corrigendum, the authorities could not be able to issue the pay the pension, madam. But he is eligible till 27 to 2000. Since 91 to 2000 tak he is eligible to get his pension, family pension.
You have completed, sir?
Yes, sir.
All right. Do you have your permission to dictate an order?
Sorry.
No. You should feel satisfied. So,
What matter? Actually, if the matters has not been placed properly, that will be inconvenience, madam. That is why I am.
we are very touched by your consciousness. Very touched. Very touched. But the man has not got pension for the last 14 years. And you say you are not standing in the way.
No. Actually, file was not with us, madam.
Very good, sir.
Previous council.
Very good. Excellent. You see, this is an appeal filed by the Union of India against an order dated 27th August 2009, passed by the single judge, disposing of petition civil 19415 of 2008, filed by the son of a deceased PNR soldier who had died, leaving behind his wife and the writ petitioner, that is the respondent herein. Stop. After the death of the father, no pension was paid, despite his being eligible for it. Stop. The mother also died. So the mother apparently was getting pension up to 31st December 1991 when she died. Stop. The respondent was only asking that he paid the pension till he attained the age of 25 years from 31/12/1991 onwards. Instead, there was also a recommendation in his favor by the Zilla Sainik Board, Benkanal, on 12th February 2007. Stop. In the above circumstances, the learned single judge directed release of the family pension from 1/1/1992 till 27th February 2000, the date on which the respondent completed 25 years. So the pension was to be paid to him within three months. Paragraph. It is now nearly 14 years since the Indian order was passed. Stop. The present appeal was filed on 8/12/2009 without even a certified copy of the Indian order of the learned single judge. Stop. As a result, the writ appeal was in defect. And since the Union of India never bothered to cure the defect, for the last 14 years, the appeal could not be listed for hearing. The paragraph. On the respondent's part, due to wrong advice, he filed an application before the Armed Forces Tribunal, Calcutta bench, which naturally could not entertain the matter. And by an order dated 3rd November 2010, in PA number 197 of 2010, the said petition was declined to be registered. Stop. Literally, the respondent has been running from pillar to post to get his arrears of pension. Stop. When the appeal was called out in response to a query by the court, counsel of the appellant admitted that till date, no pension has been paid to the no arrears of pension has been paid to the respondent, despite the recommendation in his favor way back in 2007. Stop. When asked what the justification was, since there is no stay of the order of the impugned, the stay of the impugned order of the single judge, counsel for the appellant simply stated that because an appeal had been filed in this court, the appellant, without even a stay order, did not consider it necessary to comply with the impugned order of the learned single judge. Stop. The court finds this attitude to be completely unacceptable. Stop. It must be mentioned here that the present appeal was listed since the court on its own has been making an effort to list all the old matters where defects have not been cured for several years on end. Stop. This is one such classic case where the Union of India does not bother to cure the defects for over 14 years, for nearly 14 years, and also does not consider it necessary to comply with the order appealed against. Paragraph. Even on merits, the court finds the impugned order of the single judge to be perfectly justified in law and does not call for any interference whatsoever. Stop. The appeal is accordingly dismissed. The expectation is, at least now, the impugned order of the single judge will get implemented within a period of 3 months without subjecting the respondent to further harassment.
Item number 8.
I'm sorry, my lord. I'm bother, my lord. My associate of the bother, my lord. Sorry.
See, my senior used to tell me you should do well in a bad case. So for that, I think Mr. Raiguru did exceptionally well.
I got the point, but I couldn't express well. I got the point of my lord. I'm sorry.
Exceptionally well.
Or no, exciting he is doing because he's prepared. That's why he has placed.
I'm only trying to think if we had not listed this appeal on its own, it might have celebrated some silver jubilee some years down the line.
Sorry, it is the art of a lawyer, but sometimes it is.
All right.
Sorry.
Item number 8.
None appears. Dismissed for non-discussion.
Item number 9.
Same order.
Item number 10.
Same order.
Item number 11.
Appeal lordship not pressed.
Dismissed as not pressed.
Item number 12.
I am ill, Lord. Due to my illness, it may come next week.
No way, sir. You're not even visible. What happened?
No, my Lord.
All right, for the last 5 years, no defects have been cured. This is a 2018 matter. The court does not propose to grant any further indulgence. The writ appeal is dismissed.
Item number 13.
May I please, Lord, sir? This appeal is filed against the order of the single judge, which is passed relying upon the order passed in WPC number 18824 of 2012. The present person filed a writ appeal against that order, which is number as WA 373 of 2020, and it is fixed to 28/6/2023.
List along with WA number
373 of 2020.
373 of 2020 on 28/6. All right.
Item number 14.
May I please, Lordship, on behalf of Mr. Tekera, my lord, the file is misplaced, kindly be taken after 2 weeks.
Counsel for the appellant states that the file is misplaced, dismissed for non-prosecution with liberty to the appellant to revive the appeal as and when the file is traced.
Item 15.
Infractions dismissed as infractions.
Item number 16.
None appears dismissed.
17.
None appears dismissed.
Item number 18.
Against the judgment of the Honorable Single Judge, another writ appeal was filed. That writ appeal was dismissed. The matter was carried to the Honorable Apex Court. Honorable Apex Court has given liberty. So same liberty will be given to us also to deposit the differential amount. and one of the appellant has already deposited the differential amount, my lord.
It is stated that against the, is it the same order or similar order?
Yes, sir, same order, my lord.
Against the same order dated 21st October 2021. No, against the same impugned order.
Yes, ma'am.
This court had dismissed, you say, dismissed an appeal being WA number 764 of 2020 on 21st October 2021, which was then carried to the Supreme Court of India by way of SLP Civil 7785 of 2022, in which the following order was passed. Reproduce the order. Counsel for the appellant states that civil liberty may be granted to the present appellants. Full stop. Accordingly, they are permitted to approach the authority within 4 weeks from today for the authorities to take a compassionate view of the matter, if so possible. The writ appeal is dismissed.
Item number 19. May it please minutes I appeared on behalf of Lalit Maharana. The Lordship sees on his legs on another court a short passover.
Yeah, right.
Obliged. Item number 20.
May I please, your lordship? My lord, this matter relates to settlement of tenement in favor of respondent. I did the matter. I have the order. My lord, there is a small difference. There a contempt petition was stacked, but there is no contempt petition. That is the only difference.
All right. It's okay. You see, it is stated that this matter is similar to WA number 646 of 2021, which was disposed of as having become infructuous by this court by its order dated 1/5/2023. Stop.
May I pray one line? The order of single judge modified to that extent, my lord, because this is a similar judgment.
Why modify, sir? It's already infructuous, means it's infructuous. The present appeal is disposed of in the same terms. All right.
Next two items.
21 also.
Same.
22
also.
All right.
21, 22.
All right.
Item 23.
At 22, this writ appeal has become infructuous in the meantime. This has become infructuous in the meantime.
All right. Counsel for the appeal states that the appeal has become infructuous, disposed of as such.
24.
24, the petitioner is no more. All right. The appellant stated to have expired. The appeal is dismissed as having abated.
Item 25.
25 lordship to pay 3 days time to find the certified copy of the original order.
It's a 2021 matter, madam.
Lordship, the review petition against the order passed by the honorable single judge, the appellant preferred the review petition. Review dismissed, therefore find the appeal, writ appeal, lordship.
All right.
The review petition there next, the appeal says that due to the non-filing of the certified copy of the original order, the SR couldn't be made, lordship.
This was in 2021, so.
And only matter lordship, pay 3 days time, lordship, and file the certified copy of the original order.
No, what's the matter about it, sis?
So the section 36 and 39 application filed before the Commissioner of Endowment has been rejected. Therefore, this appellant lordship prefer the rate of application lordship.
No, review is 2011 matter. It's a review pending for 7 years.
I'll just prefer one thing only. I must apologize that since 2021 the defect has not been removed. Here, my lord, the honorable single judge in the original order was pleased to.
So you could file a suit within 90 days under section 39. If you are agreed by the order of the commissioner.
True, it is, my lord. I bow down, my lord. I am only praying, my lord, subject to your lordship's kind consideration. The honorable single judge has been pleased to say that I should approach the common law forum. Review also, which is, my lord, part of this writ appeal. Therein also the honorable single judge has been pleased to reiterate that I should approach the common law forum. I pray only that. Maybe if your lordship kindly consider that, maybe upon that.
No, that is to be done within 90 days, sir.
Chances of that, my lord. There has been some communication gap which has led to this.
You can't condone that delay, sir, because this order of the commissioner, which date?
Then
it's from 2011.
Your lordship may not entertain without touching on the merit of the things. Your lordship may not entertain that much.
All right.
Your lordship
finds absolutely no merit in the present writ appeal. This is apart from the fact that defects have not been cured for over 2 years now. All that has happened by the impugned order of the learned single judge, the impugned orders of the learned single judge, that is both the original order dated
the original
26th July 2011, dismissing writ petition, disposing of writ petition civil number 11057 of 2011, and the subsequent order dated 20th July 2018, dismissing review petition number 190 of 2011, is to relegate the present appellate to the remedy of a civil suit in terms of section 39 of the Orissa Hindu Religious Endowments Act, which provides that a person agreed by an order of the commissioner, bracket, which in this case is dated
that is 7/3/2011.
7/3/2011, bracket, to file a civil suit within 90 days from the date of the sentencing. Paragraph. Having heard Mr. Samir Mishra, learned counsel appearing for the appellate, the court finds no grounds made out for interference. The writ appeal is dismissed.
Item number 26. The 26, 27, 28, 29, 30, 31. All are double filing, so I want to withdraw this. Same name to because of
it is stated that this is a case of appeals being filed twice over, and therefore these appeals do not survive and are disposed of. All right.
Item 32. 32 DLR made 25th September.
25th September.
Item 33.
30 versus with the order of the new single has been implemented. I have solved the question. All right. Counsel for the petition as a respondent.
Yes.
Places before the court copies of the orders issued on 10th May 2022 by the District Rural Development Agency, Bargarh, implementing the impugned order of the single judge. In that view of the matter, the writ appeal is disposed of as having become instructions.
That shall not be recognized. That will not be precedent.
All right. The impugned order will, however, not constitute a precedent for other cases.
No. All right. Item number 34. That requisite shall file within 3 days.
Counsel for the appellant states that he will file the date chart within a week.
No, that requisites, not
requisites. Oh, that already issued notice in this.
Yeah.
Defect also not removed, sir.
That will depend.
Right. Fresh notice be issued. In the you say requisites were not filed. In the interest of justice, one more chance, one more final chance is given to the appellants. Fresh notice returnable. 4th September. Interim order to continue.
34 and 57 is also same party.
All right.
Good luck. 35, 35, 36, 37, 38, 39, 40 and 41, 42, 43. All these matters already copies served. No, copy not served. Copy दिया है जी.
35 and 56 copies have been served upon us today and 10:35.
It's all right. What is the matter about?
That matter, similar matter has been filed to 20th July, my lord.
Okay. Yes, ma'am. All right. List, you see, counsel for the respondents accept notice, copies of the appeal be served on them. List on 20th July.
Well,
interim order to continue.
Well,
all right.
There are also 42, 43, and 45, 47, 59, 60, 61, 62, 63, 64. All these matters.
Service is complete.
Yes, my copy already served.
All right. Copies of it is stated that copies have already been served on the respondents in these cases. List on 20th July. Interim order to continue.
Item 44.
My lord, Mr. Sangram Jana is on his legs. My lord, kindly grant one password.
What? 44. 44 state, right? 44 state appellants.
What is the item number that you have? 44. No. What is the paper book you have? Which appeal?
My lord, it's item 44.
There are several lists, sir. That's why we're asking you.
My lord, this list.
You are appearing for Sangram Jana? My lords. All right, pass over.
45. 45 and 47, my lord, 20th of July, my lord. Same matter covered.
All right. 20th July. It is stated that the response have already been served. List on 20th July, interim order to continue.
46, and I have given options order, my lord. 20th of July, my lord. Laboratory technician matter.
Same 20th July. No. Notice has to go or?
Notice has document. No, this is a fresh matter.
Fresh matter.
Yes.
Notice, same order. 20th July.
48. 48 my DLF
25th September. All right. The fresh matter this is. Well, all right. Notice 25th September stay.
49.
49 minutes. I am appealing for rest of them. I am for the appellant. How come this is there today? Because it stands adjourned to 22/6.
Yes.
Yesterday we had filed on IA matter, and the worship had granted us a liberty to today because the two content section are pending matter. You say there should be stay. Registered 22 June 2023, the date already fixed. There should be stay of the imperial order of the single judge in the meanwhile.
Item number 50.
That IA is, you have to put that IA number in this 49.
50 minute, 14th of September minute, job contract. 51. At 51, outsourcing 8th August mail.
All right.
My notice to fresh mail.
Oh, fresh notice returnable 8th August. All right.
Item 52. Number 52, Sartapada 8th of May.
8th May, Monday.
This is also fresh matter.
Right.
Item 53, old commission 25th September.
Right.
Fresh matter. Notice to. Item 54.
There is some delay, my lord. Delay of only 23.
That's all right. Tell us about the matter.
My lord. Here, my lord. The proceeding was initiated, the suo motu proceeding under section 52 was initiated by the opposite party number 3, my lord. The unsuccessful petitioner lost 3 forums, my lord. Thereafter filed a writ petition, my lord. The petition will assist my kindly say, I have challenged the imperial order under annexure, my lord, 4. That is at the running page 43, 44, my lord. Para 5 of the order passed by the Honorable Single Judge, my lord. Learned on the above grounds, Mr. Mishra, learned State Council approaches the grounds raised by the petitioner attempted to support the imperial orders, wherein keeping in view both the grounds raised by the petitioner. On the first ground, this court finds family partition deed relied by the parties appears to have been undisputedly prepared in 1993 by family partition deed number 855 of 93. Statute to access any transaction after the cut-off date, that is 11/10/1973, need not be taken into account since those are all in clandestine manner to avoid sealing surplus land. What has happened? Well, in 1992, there is a registered partition deed. What should be the cut-off date in the instant case? That is the sole point, my lord. Your lordship has to decide. As per one judgment of this honorable court in the division bench, my lord, what should be the cut-off date? That has been decided in, my lord, Kasinath Panda versus State of Orissa, reported in 84 volume 1997 CLT 676 division bench. Unfortunately, I have not brought the of course that is in the book, my lord, while I read to itself. May I place, my lord, the judgment? If a person holds property in excess of their ceiling area at the time of commencement of Odisha Land Reforms Amendment Act 1973. This ceiling area has to be determined keeping in view the cut-off date 26/9/1970, irrespective of the date of initiation of conclusion of the ceiling proceeding. If, however, a person becomes liable to be proceeded under Chapter 4 because the subsequent acquisition of property or because of subsequent events contemplated in Section 52, the cut-off date cannot be considered to 26/9/70, but should be taken to the date on which the land held by him exceeds the ceiling area. In the instant case, my lord, the Boronaro irrigation project came only in the year 1997 and 98. Well, thereafter, classification of land have been changed. That is, this judgment completely supports me, my lord.
That is a citation.
Yes, my lord.
You say the impute order proceeds on the basis that any transaction after the single quotes cutoff date, i.e. 11/10/1973, need not be taken into account since these are all in clandestine manner to avoid ceiling surplus land, full stop, unquote. Paragraph. Relying on the judgment of the division bench of this court in so and so, so and so. This is Sahul Leonard, counsel for the appellant, argues that in the present case, the aforementioned date could not be taken to be the single quotes cutoff date in terms of the what is the whole statute, full cost, name of the statute? Surplus land ceiling, what is it?
Odisha Land Reforms Act 1961.
Odisha Land Reform Act 1962. 1960. Paragraph. Notice returnable. 5th September. Notice on stage.
IML 981.
Limitation is how many days?
23 days.
23 days. What's the date?
Within 1 month.
IA number 981.
981 of 2023.
All right. For the reason stated, the delay is controlled.
Delay, madam.
So, writ appeal and 982 you put together, you say notice written. All right.
Okay. Item 55.
May it please, my lord. My lord, I have filed this application for the correction of your lordship's last order dated 27/4/2023.
On this IA number 225.
This IA number is 2254, my lord.
All right.
Your lordship may kindly see on the third line of the first paragraph, your lordship has taken note of the Gram Panchayat name as Bhairpur Gram Panchayat, my lord. Your lordship may kindly appreciate.
Biripur, all right. Biripur.
That is wrong, my lord. That Bhairpur, there is no such
the first
Panchayat.
The reference to Biripur GP should be read as Ali Sasan Sasan.
That should be read as Ali Sasan. And secondly, my lord, my grievance is, even though under Gram Panchayat Act, Section 4, that headquarters should have been constructed at Ali Sasan itself. That has been now being developed at Bhairpur, my lord. And that too by order of a secretary of the...
I have not noted all that, sir. That's all right. Only the first line we correct that. The matter is still pending.
Yes. It is pending, my lord. Your lordship has issued.
Only the name of the Grand Panchayat, he wants to change Bhairpur to Ali Sasan Sasan.
Yes, my lord.
All right, all right.
And I am praying for a... Your lordship has proceeded.
No, this IA is not for, again, reviewing that order, sir. It's only for correction. All right. The IA is disposed of. All right.
Beg pardon?
Yeah, listed the same date, already listed. Right.
Lordship, may kindly correct that at least Ali Sasan it should be.
I have, sir. In your presence now, I have twice dictated that the name is substituted.
Okay.
All right. Item number 56. My lord, in this case, my lord, state has not filed counter, my lord.
It's a writ appeal, sir.
Yes, my lord.
No need for counter now.
So far as the matter involves a Anganwadi worker, my lord. Notice has been issued to the private opposite party, she is not here. And
Has
so,
been served.
my lord.
Service is complete. Who wanted to file counter?
My lord, can see the order dated, my lord, 17/5/2022 and 15/9/2022, my lord.
Okay. Achha, because no counter was filed in the petition. That was all right. Last opportunity is granted to respondents 1 to 4 to file the reply within 8 weeks. Rejoinder for the next day.
Yes, sir.
List on. August.
Item number 58.
Your lordship. Well, here, the village road was under encroachment. The agent petitioner.
After notice, sir.
Yes,
have
sir.
they all been served?
Yes, my lord. Served, they have appeared also.
My lord, I am appealing for respondent number 1, but our name not reflected in the cause list, my lord.
What is this? Put down his name. You have for respondent numbers?
1, my lord. Purnachandra Mishra.
It's there. No, in the cause list it's not there. The name of Mr. P.C. Mishra be reflected in the cause list for respondent numbers 1 to 4.
No, my lord, only 1, my lord.
1.
What about the others?
They all were the petitioner before the.
They're all your brothers, sir.
It belong to one family.
2 and 3 are your brothers.
Yes, my lord.
But I think 4 is your mother. No, not mother. Sister maybe.
Yes.
They're all your relations.
And they were the petitioners. So,
why only for 1?
My lord, construction of my senior batch.
How can it be? Anyway.
My lord.
All right. List on. 13th September.
Item 59.
Yes.
Nana paste.
59, sir.
59 that 20th July.
Yes, 20th July. Sorry.
Item 60.
60, 61, 62, 63, 64.
All 20th July. Right. You have to say they have all been served. The respondents have been served.
Yes, yes, ma'am.
Copies of the writ appeal have already been served on the respondents. Right.
65.
65, similar matter, you will also fix to 29th August. Regarding maintainability of the writ appeal in case of a dispute which is arising out of an election tribunal case.
That is not a similar matter, my lord. That is the order 7 rule 11 petition was rejected. Challenging the order rejection, my lord, he filed a read petition.
I will come to the main petition because the maintainability will be settled first. That's why, my lord, I am pleading. That will be arguments will be advanced by Mr. Gautam Mukherjee, learned senior counsel on that day.
That is it. With regard to that is order 7 rule 11 petition was rejected. And in the meantime, also evidence has already been started, and the 2 persons have already.
Anyway, we are not issuing any stay.
Yes, stay order has been granted.
Here, yes, my lord.
On 2010,
prima facie being
passed the stay order. By virtue of the stay order, that is that. Because the evidence has already been closed, matters. The evidence 2 persons have already given the evidence, and they have already cross-examined the matter. The inspection matter that is only for matters. In the meantime, 1.5 years have been passed.
You argue on maintainability then, sir? Or the stay will have to be vacated then?
My lord, here maintainability, your lordship being prima facie satisfied, you should notice. It is a matter which arising out of an election tribunal order. So that is maintained.
We have filed a 711.
Yes, my lord.
And that has been rejected.
That was rejected. Honorable single judge, my lord, confirmed that order. Against that order, I have come in a writ appeal.
Right.
Now, your lordship may see writ appeal is maintainable here because in view of the decision rendered by our Honorable High Court in 2019 to OLR 609, actually there's a full bench here, sir. 2011 full bench is there. That is, my lord, I was verifying. It is under section 100A of CPC. Whether that will be maintainable or not, writ appeal against that. That is the crux of that decision of the full bench. Now, division bench decision here states that an appeal against order division bench take note of that full bench. No, that has not been taken note. But the division bench is clearly on the point of election tribunal, whether that is under 226 or 227. The election here, this honorable court, the division bench has held that under 226 and 227 powers the orders are applicable as writ appeal. Yes. 2019 to my lord, philosophies. That is solely on this point only. Thereafter, on the merits, my lord, if your lordship may see, an election petition has been filed against elected Sarpanch, only giving 2 dates that he has 3 children and that those 3 children were born on this and this date. There is no other particular, nothing, not a single line. From where did that information come? Yes. From where, my lord, what are the name of the children? Where are they? Nothing of that sort, my lord. Oh. So, under that, your lordship may see the election petition, my lord. Election petition, page 13. Yes. And internal page 3. This is the only 2 lines which has been mentioned to call in question the election. The OP1 gave birth 2 children on 3/10/2009. Again, OP number 1 gave birth another child, boy child on 14/12/2019. Hence, the OP number 1 has more than 2 children after the cut-off date. She is disqualified person to contest the post of Sarpanch. This is the only allegation which has been made. Entire petition, there is nothing. So, in view of that, my lord, where section 35 of the Gram Panchayat Act says that every material particular facts has to be placed so that that can be laid in evidence. Now, this only 2 line calling in question the election, that cannot be maintained. Evidence has already been laid, sir. Yes. No, that was not correct. He says it's only a stage of arguments. Yes, now. Just shows that. How many witnesses were examined?
2 witnesses have been examined and they are cross-examined.
Oh.
They are cross-examined by opposite partner 1 members.
Oh, I see. And their evidence is to be led now.
Now their evidence should be led.
No, I do not have even the what evidence are to be led, who are to be examined, my lord. That is also not there in the pleading. Pleading is silent completely. They have already examined. This person is now pleading. 2 of the witnesses have been examined. The election petitioner may be that I do not have the copy. Here, he's giving you. Yes, the election petitioner may have been examined. No, 2 witnesses. He has no more witnesses, he says. You have any more witnesses?
No, we have already given 2 witnesses. Then my lord, then the my lord, that evidence, that is the Honorable High Court state the matter, my lord.
No. How many more witnesses do you have?
That, my lord,
if we lift the stay now, do you have any more witnesses to examine, or he has to examine his witnesses?
That first I will give you another 1 examination, my lord, 1 evidence, then my lord, he will start.
My lord, evidence without any pleading. That is, Order 6, Rule 2 is clear, my lord. The pleading has to be first, and to substantiate the pleading, evidence has to be laid. But there are only 2 dates, and there is nothing more on the petition. And section 35 being clear to that aspect, my lord, that cannot be allowed to continue. This is only pure harassment to my lord, elected body. I will cite decision on that aspect, my lord. The decisions are under the Representation of People Act. One decision reported, year 1986 Supreme Court 1253. This is under the Representation of People Act. Here it says, I'll just come to the relevant portion, my lord. A single material fact would lead to an incomplete cause of action. That an election petition without the material facts relating to corrupt practices is not at all election petition at all. Similar is the judgment, my lord. Another case, my lord. Here regarding Order 6, Rule 1, the object of the pleading. This is here 1987 Supreme Court 1242. Order 6, Rule 1, pleading, object and purpose. Question about lack of pleading. It is not desirable to place undue emphasis on form, instead substance and pleading should be considered. So, my lord, in this case, it's Panchayat Act. Section 33 of the Gram Panchayat Act states, contents of a petition, an election petition shall contain a concise statement of material facts on which the petitioner relies. Material facts. Here, nothing of such has been stated except these two dates. Then shall set forth full particulars of any corrupt practices that the petitioner alleges, including a full statement as possible of the names of the parties alleged to have committed such corrupt practices and the date and place of the commission of each such practice, and shall be signed by the petitioner and verified in the manner laid down as under. That is different. Well, come to para 9 of this page 30, running page 30, sir. My lord, in the case in allegation of the election petitioner against the OP number 1, that on date of filing of nomination, OP number 1 was disqualified to contest for the post of Sarpanch of the Ratnagiri Gram Panchayat, as she had given birth to 3 children after the cut-off date. The petitioner has mentioned the dates of birth of 3 children in her petition. If the OP number 1 had not appeared, this court could not have given. No, this court could have given. If he had not appeared, this court could have given a direct verdict. Yes, on the basis this is impugned, this order this is enough. So the question is, were these pleadings enough for the election tribunal to proceed with the matter? And they say if you had not gone and contested the fact that you had 3 children after the cut-off date, the dates of birth being given, that would have been more than enough. If it was not controverted, they were straight away allowed the election petition. That is how you test the pleadings. Bow down to your lordship, but yes, that is under challenge. Your lordship, the question is adequacy of pleadings. Yes. They are not on the merits, sir. You are trying to argue that there are not sufficient arguments in the election petition for the election tribunal to entertain the petition in the first place. That is your argument. Correct, ma'am. They are not on the merits, for which the election tribunal is pointing out, yes, since it has been averred that you have 3 children beyond the cut-off date, my lord, their dates of birth have also been given. There's nothing more to be pleaded. Where did my lord, where did the Sarpanch, elected Sarpanch, give birth to these children, and what is their position now? Those are matters of details, sir. Those are actual particulars in as much as that is not the material. Material particular is having more than so many children after the cut-off date. That's the material particular. Well, and the dates of birth. Then the object of the entire pleading about material facts, which has this is a material fact. The place of birth does not become so material. No, not be valid. But in this context, the context is number of children, correct? That's the context. That is the place of birth of these children is not material. If that is gone into evidence, my lord, they have to bring in the evidence what are the name of the children and what. In the first place, a preliminary objection is raised by counsel for the respondent on the question of maintainability of the writ appeal, relying on the judgment of the full bench of this court. Mahmood Saud versus Dr. Major Sheikh Mahfouz, 2008 to OLR FB 725, which has been affirmed by the full bench, by the Supreme Court, in that say Mohammed Saud versus Dr. Major Sheikh Mahfouz, 2010-13 SEC 517. This is in the context of the fact that against an order passed by the election tribunal on 6th May 2022, rejecting the application filed by the appellant bracket, who's the successful candidate whose election has been challenged by the respondent, whose election to the post of Sarpanch of the which Gram Panchayat is? Ratnagiri Gram Panchayat. Ratnagiri Gram Panchayat
has been challenged, bracket, filed an application under Order 7 to 11 CPC for rejection of the plaint. Full stop. With this application having been dismissed by the election tribunal, the appellant then filed writ petition civil 22309 of 2022, which also came to be dismissed by the learned single judge by the impugned order dated 27 September 2022. Full stop. That writ petition obviously was entertained in exercise of the jurisdiction of the learned single judge under Article 227 of the Constitution of India. Paragraph. It does appear therefore to this court, full stop. Counsel for the appellant, on the other hand, relies on the decision of a division bench of this court.
That is not copy. That division bench decision, my lord, that is not there. 2019 12. This is the other decision of the Supreme Court.
Give us at least a citation.
Yes, I'll just provide. 2019.
2019 2 OLR. What page?
609. 619.
619. Full stop. However, it is not in dispute that the said division bench did not take note of the full bench decision of this court in Mohammed Saud Supra. Paragraph. In view of the judgment of the full bench in Mohammed Saud, this court is not prepared to accept the plea of the present appellant regarding maintainability of the present appeal. Paragraph. Nevertheless, the appeal has also been examined on merits. The ground on which the rejection of the plaint was sought was that it did not contain the material particulars. Full stop. The main ground of challenge is that the present appellant had 3 children beyond the cutoff date and therefore was disqualified for contesting for the post of Sarpanch. Full stop. Qua that ground, there was pleading in the election petition of the fact of the appellant having more than 3 children, with the dates of birth of the 3 children being set out. Full stop. Paragraph. Counsel for the appellant argued that the places of birth of the 3 children were not indicated and that the said detail was some material particular. Full stop. This court is unable to agree. At the stage of pleadings, as long as it is clearly stated that the present appellant had more than 3 children with their dates of birth being set out, the mere fact that their places of birth was not indicated would not mean that the petition lacked material particulars. Paragraph. It may be pointed out here that prior to this court in the present appeal staying further proceedings in the election petition by the order dated 2010-2022, 2 witnesses of the election petitioner had already been examined. The transcript of the evidence has been placed before this court today. Full stop. Inasmuch as the trial is already underway, the full facts concerning the ground of challenge will obviously emerge in a very short while. Paragraph. For the aforementioned reasons, this court is unable to find any error having been committed by the election tribunal in rejecting the appellant's application under Order 7 to 11 CPC by the order dated 6th May 2022. Full stop. For that matter, no ground has been made out to question the impugned order dated 27/9/2022 of the learned single judge. Consequently, the appeal is dismissed. The interim order is vacated. A copy of this order be sent to the concerned election tribunal, that is the court of the civil judge junior division come election tribunal Jajpur, who seized of election petition number 10 of 2022 forthwith. All right. Pass.
Pass to matter item number 19. Item 19.
Lordships, I appear on behalf of Mr. Maharana. Your Lordship, he is still on his legs before the
All right. Counsel, the appellant is stated with some personal difficulty today. List on 1st August.
Obliged, Your Lordship.
Item 44.
Your Lord, I have filed an IA for modification of lordship order, my lord. Though the matter relating to ad hoc promotion to the post of Deputy Superintendent Police, or the matter was listed along with the batch of writ appeals which relating to the regulation. Also, kindly see page 6 annex A to order dated 25/4.
That matter has been wrongly tagged. This is a first day disposal. He wants.
Yes,
that matter can be
also
remanded to the
relax
order.
that order, my lord, annex B, page 8.
Page 13 is the.
Similar matter is also already remitted back to the single judge.
All right. It is pointed out in this application that the present appeal is similar to writ appeal number 38 of 2022, and therefore a similar order will be passed as was passed in the said writ appeal. For the reasons stated therein, the application is allowed. And in the main matter, you say, it is seen that the impugned order of the learned single judge was passed on the very first date of listing of the writ petition without any opportunity to the present appellant to file a reply. On that short ground, it is hereby set aside. And writ petition civil 26564 of 2021 is now restored to the file of the learned single judge in the roster bench, where it will be listed for hearing on 4th September 2023.
17 July also direct in that case.
That matter 17 July, is it? Okay, 17 July 2023.
Annex B is order I am doing in the IA. Same order. Same order.
So same order then.
Well,
as an action. The writ appeal is disposed of. The next date is cancelled. All right.
Supplementary fresh submission item number 1, ARBP 8 of 2023. ARBP 8 of 2023.
None appears, so the petitioner none appeared on the previous date, that is 17th March 2023 either. This was for non-prosecution.
Item number 2.
Yes. The agreement is at page 8 and the relevant page is page 18. Man. One 8. Man.
All right, notice returnable. June.
Item number 3.
So, the 11.6 and my lords, 11 plus 11, page 45, my lords. Plus
all right.
4.
Notice returnable 7 July.
My lords.
There are similar matters.
Similar,
right?
my lords, or 3, 4, 5, 6, my lords.
3, 4, 5, 6, and then there's something else also further.
No, that is in orders. Orders. 3, 4, 5, 6.
3, 4, 5, 6, same order. All right.
Item number 7.
I appear for the petitioner, my lords. My lords, this is a section 11 for appointment of arbitrator. My lords, clause 16, my lords, that's the arbitration clause, my lords. It's on page 166, lordship.
All right. We should say notice returnable 7 July.
Mallards, may I request for any date in June, Mallards, maybe last week of June?
30th June. All right.
30th June. I'm grateful. I'm grateful.
Item number 8.
May I please, Your Lordship? I'm appearing from virtual court from Koraput, Milord.
Yes.
This is an application under section 11 of arbitration, Milord.
Yes.
Cancellation Act for appointment of arbitrator.
All right.
Page 21, clause 34, annexure 1, Milord, that deals with the arbitration procedure, appointment of an arbitrator. Refer to an arbitrator, Milord.
1 minute. Right, right, all right. Notice, all right. Notice returnable 7 July, sir.
Publish.
Item number 9. Item 9.
Pass.
Item number 10.
10, my lords, defect is at page 772, not legible copies, my lords. I'll supply the legible copies, my lords. Meanwhile, I'll remove the defect by Monday. Notice for similar matter as 635.
All right. Notice returnable 7 July.
7 July, my lords.
Defects be cured in the meanwhile.
In my lords.
The same for 12 also.
12, my lords, copy already served, my lords. The defect is copy not served.
All right. 12 you said notice returnable same 7 July.
My lords. Notice, that is, there are 4 opposite parties. Only one notice and 2, 3, 4, I think government will accept. I've already served.
2, 3, 4. Yeah. 2, 3, 4. Say notice only returnable. He accepts the 2, 3, and 4.
2, 3, 4.
Right.
7 pilots. The returnable.
7 July.
Right. Obliged much.
Item 11.
Page 30, clause N is the relevant portion of the appointment for arbitrators.
All right. Notice returnable 7 July.
Item 13.
And in that item one opposite part number 1 is Ostoma. He is to be noticed. In item 12.
You are accepting for 1 also.
No. 2, 3, 4. Correct.
Yeah, correct.
Item number 13.
Notes. This is an 11/6 application, minutes. The readings are completed. I filed my rejoinder.
I appeal for the respondent opposing the application.
Yes. No, you're opposing it.
Yes.
So tell us the grounds of opposition.
My lords, the grounds for opposition, my lords, is that in this case, we are the insurance company.
Right.
Claim was made. The amounts have been paid. Discharge vouchers have been given. There is an accord satisfaction. Everything has been done. The company was under NCLT. IRP appointed. The committee of creditors, the board, the IRP had a meeting. Everyone decided that yes, we should take this money as full and final settlement. Minutes have been put on record by them. Pursuant to those minutes, amounts were paid to them, discharge vouchers given, and after a few months they write a notice saying that this amount was accepted under duress. And a notice given by an advocate when the board is under suspension on the behalf of the board and not on behalf of the IRP. Whereas the IRP has already given a discharge certificate, my lords. And today claim discharge, and today there is no arbitrable disputes, my lords. A similar case was before Supreme Court 20 days ago. A judgment has been passed where the Supreme Court refused to appoint an arbitrator, saying there is accord and satisfaction, and my lords, amounts have already been paid, my lords. Yes. Just give a copy to the other side. This was decided on 10th of April, my lords.
Yes,
today the issues raised by them, my lords, a claim of 10 crores was raised, 3.5 crores, my lords, final survey report was given, amounts given. Now today, by an advocate's notice, a claim for almost 50 crores is being raised. Claims which were never there before the respondent as far as the incident is concerned.
It's a fire claim, is it?
Yes, my lords.
Loss and burglary, fire and burglary.
In my lords, we'll just see the rejoinder filed by my learned friend for a moment, and the minutes of the meeting, where each and every director says that yes, please accept this amount as full and final settlement. My lords, we'll see the rejoinder filed by my learned friend, which was given to us yesterday. We have gone through it. Annexure number 9, and page 15 is the minutes, my lords, after which the amounts were given to them. And page 16, my lords, will see item number A3.
Right.
Discussion regarding insurance settlement voucher to New India Assurance Company. New India Assurance Company has approved a claim of 3 crores 94 lakhs pertaining to the loss so and so. This is being discussed, and my lords will then come to my lords next page. In the matter, all the committee of creditor members discussed and briefly shared their opinion as follows. Mr. Anil Kumar, suspended director, expressed his opinion at present situation and on good faith for the amount has been accepted as full and final settlement. final amount will be rupees so and so, but it is important to appoint an expert to point out regarding sanction claim value. They said that we are taking this amount as final. We will appoint an expert and see whether the amount is proper or not. No expert appointed, nothing at all till date. They haven't come back saying that we have appointed an expert as per the expert instead of 3.5, 4.5, 5.5 or 10.
Because the next page is the conclusion.
Please,
there's no point explaining that at a short time. The next page is the conclusion.
Yes, let me come to that. Let me read what
point number 2, Milord, the conclusion.
I was reading what each and every director is saying. Each and every director is saying.
Milord, may I respond? I'll finish up in two, 3 lines.
Let him. Yes. Then my lords will see item number 2. Each and every director, IRP and the committee of creditors are saying, please accept it as full and final settlement. And then my lords will see resolve. Conclusion. My lords will see the next page conclusion. RP has been authorized to sign the settlement letter full and final payment for cost board, insurance and the policy towards damage to the building, plant, machinery due to cyclone Fani. And a deduction premium of so and so claim amount. RP, second point, RP has to appoint an expert to get an opinion, reconcile, review claim and find out justified claim amount, loading charges, etc. whatever, whether it's unfair. Nothing of this kind has been done till date. And then the RP has been appointed to collect the amount, and the amounts have been paid, discharge vouchers have been given, my lords. And my lords will see in the petition itself. After all this, what is the notice that they give in the petition? Please come to their petition under section 11. And please come straight. And before that, my lords will come to my R16 in our reply to see the discharge voucher signed by the RP. Pursuant to this minutes, the discharge voucher signed by the RP, which is annexure R16 in our reply at page 271. In fact, he thanks us for all the help and then signs a discharge voucher. 271A, my lords, page 271A. Yes. Of our reply is the discharge voucher signed. And my lords will see, I, Umesh Chandra Sahu, hereby intimate to your good self, so and so, as per section 17, the power of the boards are vested, appointed so and so. And then my lords, settlement discharge voucher, and next page, my lords, settlement intimation voucher has been signed by him, right, where the amount has been received. After receiving all this, my lords, what do they do? Come to the petition, my lords. Please see in the petition what happens after they receive the amount. Couple of months after they receive the amount, we get a letter, my lords, which is at page 42, my lords, it starts. Annexure 6. This is a letter written by, no, sorry, this is not, sorry, this is accepting the amount. This is accepting the amount. The next letter is at 43, my lords. 43, yes. 43 is a letter by an advocate a couple of months after receiving the amount and written by on behalf of the board, which is still suspended, where the proceedings before the IBC are going on. IRP is in charge. The board is suspended and he writes a letter on behalf of the board. And please see what is written in the letter. My lords will come to paragraph 8. You have coerced our client, that is IRP, in sending such a letter and signing the settlement voucher. Where is undue influence? Where is coercion? Nothing of this kind is there. Not a word. And please now, my lords, will come to the next page, the claim made at paragraph 10. And it says that para 10, the committee of creditors in the recent proceedings took a decision to challenge the lawful and unlawful and arbitrary reduction of the claim. While we saw in the minutes where committee of creditors is saying, please take this amount as final settlement. Where is this minutes that they're talking about? And after that, my lords would see the table. The very first amount is 11 crores. Their claim was 10 crores. Earlier it was 24, then 15, then 10. Out of 10, 3.5 has been given. They go back to their claim of 15 and ask for 11 more. Keeping that aside, please see the rest of the claims. Nothing was there. No such claims were ever raised. And they can't even be raised in the policy. A claim of 35 crores is raised for loss of goodwill and mental agony. None of these claims were there. There is complete effort and satisfaction. Nothing to be.
Let's hear.
Yes, my lords. And then my lords, just I haven't gone through the judgment. My lords may hear my learned friend, then I'll just place the
Bugara, Prolifab, all of that.
No, not those. The latest judgment. The latest. This is after dealing with all that. I have seen those Bogara master and judgments are all dealt by this judgment.
Everything is follows from Bogra. Bogra is the first judgment.
Correct.
That I will explain how I am not coming under Bogra. Before that, the arbitration clause.
Yes. This last judgment, which was given on 10th April, considers each and every judgment on this point under the law. Prior to the 15th Amendment, after the 15th Amendment, and the latest judgments, and comes to a conclusion. This was also a case where a settlement was done, amounts were paid, and few months after that, new claims were being raised. And the court said no. Yes, please.
Thank you. Clause 13, Millards at page 34, is the arbitration clause. If any dispute or difference shall arise as to the quantum to be paid under this policy, such difference shall independently of all other questions be referred to the decision of the sole arbitrator to be appointed in writing by the parties to, or if they cannot agree upon a single arbitrator within 30 days or any party invoking the arbitration, the same shall be referred to a panel of 3 arbitrators comprising two arbitrators, one to be appointed by each of the parties to the dispute difference and the third arbitrator to be appointed by such 2 arbitrators. An arbitration shall be conducted under and in accordance with the provisions of the Arbitration Conciliation Act 1996. There is no accepted matter, as my learned senior is saying, that these claims cannot be raised. Any dispute.
No, we are on accord and satisfaction.
Yes, first that I am just addressing that. Now going to the accord and satisfaction. Because the funny accord in Millards on 3/5/2019, 7/5/2019, an insolvency application was filed. During the insolvency process, the CIRP was issued, and I had the RP issued them as accord and satisfaction letter. Now, Millards comes to my annexure of the rejoinder in the rejoinder Millards. Page 360.
Yes.
My learned senior said that thanks has been issued by me by the RP. That was prior to the issuance of the money. After that, there is no thanking letter to him. Now, coming to 360 Millards. The conclusion I am reading, Millards, at page 18 Millards, running page 364 of the application. Yes, please. Point number 1, point number 2, Millards. RP has to appoint experts to get opinion and reconcile, review the claim to find out the justified claim amount and loading charged by the New Indian Insurance Company Co. Limited, if any unfair valuation or unjust amount that has to be made calculated. Let me read that way. Made by insurance company has to report COC for further proceedings. Now, Millards, comes to my letter dated 8/2/2021.
Yes.
Page 48 Millards.
Yes.
Para 10. That the COC in the recent proceeding took decision for challenging.
When was this vote?
Yes, madam.
When was this proceeding, please?
Millards, yes. I have filed, as my learned senior is saying, that I have filed on behalf of the board. That is not correct.
No, we come to that point. That's a separate point. Yes. You are referring to a recent proceeding of the COC, which is this.
I don't have that, Millards. I can't have this because
you can't make an amendment like this without having the document in front of you, sir.
Millards,
because you say it took a decision. That decision can't be an oral decision.
No, Millards, cannot be an oral decision, Millards. I fully agree. Because for that, I have to call the RP as a witness under section 29 of the Arbitration and Conciliation.
No. You're completely mistaken on that.
Millards, I'll read out 29. Millards, I'll read out 29.
Yes. No. First, you have to have an amendment, please.
Yes, Millards.
You have to make positive an amendment that the experts pointed out that this was undervalued or underpaid. That expert's view has to be placed before the COC. The COC has to deliberate on that and take a decision. Yes. That is the minutes of the COC which you are referring to.
I have to paste that.
Yes.
The minutes of COC, I am the present management. COC and the RP are two independent bodies which are beyond my control. I have to get control.
It's not about control.
Yes, Millards.
You are representing the company now when you issue this notice.
Yes, Millards.
The company is instructing you as its lawyer that we had a meeting of the COC in which a decision was taken. Yes. You are just parrot-like repeating it without giving the details of when that meeting took place, what was decided in that meeting. Even if you did not have those details when you sent this notice, at least when this petition was filed, you should have had those details.
Let's reply to that, Millards. they receive this notice. They don't raise that objection.
No, there it's
I issue
you
the
are the
section
one. See, you are coming to the court, you
Yes.
are asking for the appointment of an arbitrator.
Yes.
If the burden is on you, and
Yes,
you
I
have
just-
to show how a decision was taken to challenge this claim.
Just one reply. My reply to this is threefold, Milords. One, I issued this notice. I issued them a section 21 notice as a reference notice. Nowhere they come out and say that this is this. That's why we're not going to appoint an arbitrator. They straight away bring this point here.
They are not obliged to.
Milords.
You are the one seeking the appointment of an arbitrator.
Now, Milords, as in the 11-6 court, Milords, it has to be limited to the prima facie view of the dispute. Now, here I say that there is a COC meeting. Now, in the arbitration tribunal, I'll establish that there was a COC meeting. And section 29 for that, Milords. For that, section 29, Milords.
1 minute of the meeting, my learned friend has already placed on record in the joinder. He could have placed this also.
Yes.
Milords, section 29.
Yes. Please remember the defense is accord and satisfaction. You have to answer that. 29 is nothing, let's say. This is only a decision of the arbitral tribunal. 29 is not relevant here.
Milords, 27, Milords.
All right, get a witness.
27. Yes, I will get a witness, Milords. I'll get the RP as a witness, the COC members as my witness.
That comes
Now they will say that yes, had the meeting had happened or not, Milords.
In your pleadings, you have to lay a foundation, correct? That foundation doesn't exist.
Milords comes to my rejoinder.
You're fully aware that the resolution professional issued a letter to them accepting the claim in full and final settlement.
Yes, Milords.
Thereafter, if you want to overturn that,
yes, Milords.
It was conditional upon the company appointing a committee of experts, the experts examining whether the claim was settled for a lesser amount, the decision of the experts being placed before the committee of creditors.
Now, Milords, my reply is the prima facie dispute. There should be a prima facie dispute.
No.
For appointment.
No.
Accord and satisfaction has to be dealt by the honorable arbitrators. That is my first argument. Second phase, Milord. Second thing of my submission, Milord.
Yes.
They are relying on a judgment which flows from Bogra Police. Bogra says, Milord, that once the arbitration proceeding has been issued, you cannot go back and settle and come back again to begin the arbitration proceeding. Here, that is not the case. I have never begun the arbitration proceeding before getting the amount.
All right.
And the thanks and accord and satisfaction that they are reading, it was prior to that. So there is no accord and satisfaction.
And where is the question of coercion? You're simply alleging that there was coercion. Where is the coercion?
Yes. RP is just appointed on behalf of the COC. He is to handle the management on behalf of the COC. His whole purpose is to get the most finance that can be generated to either make the company running or to.
If you are alleging there was coercion,
yes,
you have to prove it.
Exactly. I am the new management.
Make an allegation.
I am the new management. I have to establish by getting the RP as a witness.
No. You can't simply, unless the RP told you, listen, I was coerced into agreeing, you can't simply make an allegation like that.
Company is an initiative. What can be more economic duress than that? I was going, CIRP proceeding was going against me.
No, sorry.
What can be more economic duress than that?
Sorry, I'll pass the detailed order.
Just one point, just for consideration. Even if the accord and satisfaction has been challenged, it has to be adjudicated by an arbitrator.
No. If you make out a case, yes.
Yes, the prime case, that's why I said page 10, that there was a meeting, but I cannot get it now because I am the new management. COC and RP, their communications, I cannot get it.
No.
Because
anything to do with the company has to be in writing.
I'll explain.
There has to be minutes of it.
I was not there when the COC. I am the new management.
No.
Agency here.
The company continues, only the management changes. So the company's records are very much there with the company.
COC committee meetings, that's the company management.
It's not even your case that you do not have the minutes of those meetings. When I ask you the question, you're telling me this is not your case.
Once the arbitrator is appointed, they deny that before the arbitrator, I will provide a document. I will not provide. Again, I will ask for expert witness.
in fact, the minutes that we relied, they have shown COC is present and COC is also saying accept this amount.
No, COC is saying appoint the expert to just check.
Anyway, there's no expert appointed anyway.
Right.
All right.
No, the expert is expert is appointed. I said in my rejoinder that I prove it
something for that. You have to show what is the reward.
The COC will not give it without expert.
No question. All right. The petition is dismissed. I'll pass the detail. You'll get it on Monday. All right.
Item 14. May it please your lordships, my lords, I beg to appear for the petitioners in this matter. My lords, by your lordships order of 24th February 2023, your lordships directed the respondents to file a reply within 8 weeks. Now, we have not received a copy of a reply, but my lords, in the meantime, my lords, may I indicate the existence of the arbitration agreement is not in dispute. Rather, only on, my lords, they have not consented to the appointed, my lords, the nominated arbitrator from our end.
He wants to say something. 1 minute, he wants to say.
I seek for a short account. I have received instruction. I need to find the counter. I also intimated the.
All right, last opportunity to be counsel the opposite parties to file a reply within 4 weeks.
It's 23rd June, in the immediately after reopening, if I may just pray to your lordships.
All right.
All right. I'm so grateful. So grateful.
All right.
Deeply.
Item 15.
Item 15, we have already received the PWC or draft ready within 10 days. We'll file this.
Opportunity to file a reply within 4 weeks. Rejoined for the next date. This is 7 July.
Item
Along with me, Mr. Kashyap is appearing.
All right.
16.
Item 16, my lord, I am appearing on behalf of Mr. Biswal.
I am for the respondent.
Actually, we received counter yesterday. I am praying for 2 weeks time for filing rejoinder.
What are you saying your counter?
Not my wakalatnama based on record.
Right.
Here in the counter, I have raised, of course, denied and disputed the allegations, but I had one submission.
Yes.
If your lordship will have para 4 of my reply.
Right.
I have stated that in the notice of arbitration that was issued, I replied to that, calling upon the petitioner.
Anyway, are you prepared to go into mediation even now?
No,
He's ready to go for mediation.
No, my lord, I am praying for 2 weeks time.
No, 2 weeks time for what?
For filing rejoinder, my lord.
Rejoinder is there. Suppose we decide if you don't go in for mediation, we refer you to arbitration. I don't think you can oppose that. That's your plea?
Actually, my senior is not there. That's why
I was, of the opinion that mediation will be a win-win situation because the petitioner is an individual and it will unnecessarily obviate the arbitration cost and all. Very well, if my learned friend has.
All right. Rejoinder will be filed the next day. Let's on 7 July.
Great.
13 July. 13 July.
Grateful.
Item number 17.
Visual Lordship. 3/3/23 Lordship notice was issued to the opposite party.
You say
has refused.
Yeah.
As shown.
All right. You see the postal endorsement of service of notice on the respondent is open quotation refused by addressee. The respondent should be taken to have been served. What is the claim, sir?
Claim Lordship and dispute here that the petitioner is the proprietor of the agency. The opposite party was also the authorized person for looking after this. And there was an agreement initially between the husband of the petitioner and thereafter the petitioner, OP2. The Lordship, page 12. What is the dispute? There was each party shall have share the business and shall get half of this profit, shall liable half of the loss there. Then the Lordship, there in case any dispute.
No, what is the monetary claim?
That has to be adjudicated because there he is not paying anything out of the profit from that agency, gas agency business.
Will appoint an advocate?
Yes, ma'am. Santanu Sarangi, senior counsel.
I think he's already flooded with too many arbitrations. He's already got so many. Anyone? Anyway, I'll put the name. Let's say so-and-so's advocate is appointed as sole arbitrator to retrieve the dispute between the parties, including the claims and counterclaims. The arbitration will take place under the aegis of the arbitration center. All right.
Obliged.
Item 18.
18, Your Lordship, you are appearing for the first time. 2 weeks' time, Your Lordship.
Who's for the petitioner?
I'm for Your Lordship, I'm appearing for the petitioner.
Still, the deficit court fee has not been paid.
That has been paid, my lord, already paid, my lord.
All right, it stated the deficit court fee has been paid. Ms. Ratha, appearing on behalf of the respondent, seeks and is granted 4 weeks' time to file a reply. All right. Some neat pages and all not filed, remaining secured in the meanwhile. List on 13 July.
Your Lordship will also give me an opportunity to file a rejoinder, Your Lordship.
We'll give you that. All right.
Pastoral matter, item number 9. Item 9.
Withdrawn. Withdrawn. All right. Counsel, the petitioner seeks leave to withdraw the present petition. Dismisses withdraw. All right.
Specialist. Item number 1, CRLMC 3346 of 2015.
Your Lordship, item number 1 permitted to withdraw.
All right. Dismisses withdrawn.
Item number 2.
None of it dismissed.
Item number 3.
Same order.
Item number 4.
Case is that your Lordship may kindly turn to the RPFM fast text of 176 of 2016, page 15, the exhibit, man. Exhibit B and C and D.
Yes, tell us.
Yes, the opposite party is the wife of the late Khageshwar Kannur. The sub-collector, the Madhu Pension Yojana is taking, as a widow, taking pension. My case is that he is paying fraud and not come to the court in clean hand and suppression of the fact. He is getting pension somewhere else and here he is claiming maintenance. No proof of the marriage and the near relative has never said about the date of the marriage. And the third point is the res judicata. Earlier, the case has been dismissed by miscase number 10 of miscase number 19 of 99 in 15/3/2003. That is the page 15 of the district judge order, madam.
Yes, page 3.
Page 15 of the district judge. Kindal miscase, first case 3125 of 2016 is clearly page 15, paragraph 5. May I read, madam? It is submitted the learned advocate on behalf of the present petitioner that actually there has been no marriage between the petitioner and the opposite party number 1. Further, the opposite party number 2, this child, previously the opposite party number 1 preferred miscase number 19 of 99, which was dismissed for default for 15/3/2008. After remaining silent for 6 years, again, here the opposite partner along with another present petitioner filed false averment only to extract money. Then your Lordship kindly turn to the page 16. Next page.
Yes.
The presumption of marriage in the absence of any evidence, marriage ceremony or even unsatisfactory evidence of marriage may justifiably be made when person concerned live together to some period of time, had been treated as husband and wife by the family or friends of the neighbor. Then the middle portion, madam. According to a woman cannot be granted order against a man unless he proves himself to be legally married wife according to his personal. That is the. Then your Lordship, next page, madam, page 17, paragraph 8. It is a fact that present opposite party have failed to clearly prove any.
You are for the wife.
Yes, sir. Yes, sir.
Have you got any money? No. Has he paid you anything?
Yes, current maintenance is going on.
You're getting 3,000 per month.
Yes, Your Lordship.
And for the son?
Fine is major, your lordship, that's why it's not.
Nothing. So just this 3,000.
Yes, your lordship. This
You are fighting tooth and nail to give her 3,000 a month.
No, he's not my wife, my lord.
I see.
I'm my specific case is that he's not my wife.
All right.
No, your lordship, legally married wife.
The
your
Madhu
lordship.
pension is, your lordship, I will give supply of the document. Your lordship.
1 minute, just 1 minute. This is not like all evidence was laid in the lower court.
Yes.
Not for you to simply hand over documents like this.
No,
What is the princely sum she's getting? What is the huge sum she's getting in Madhu Pension Yojana, according to you?
According to him, he is getting 300 rupees.
Huge, very huge sum.
No,
excellent.
I can't say.
Such a huge sum. Such a huge sum, she should be able to very well maintain herself.
That's right. Amount may be less or higher.
What maybe? What is this maybe?
But in the Panchayat Samiti record, he has stated wife of somebody else, and voter identity card is wife of somebody else.
You were given a full opportunity to lead evidence. You failed miserably. You're now arguing on top of that evidence. That's the whole problem.
And
yes,
that's your lordship in our High Court 2 decision I am citing.
Yes. No pleadings, but no evidence, but decisions. Yes.
I will lead the matter.
Decisions cannot substitute pleadings or evidence, sir.
Your lordship.
First, you have to make your case on facts, then we'll come to decisions.
Yes, sir.
You have no case on facts, but you only have decisions.
Then your lordship kindly turn to the judgment which the learned court and deal that point.
How much have you spent in this litigation? No problem. But paying 3,000 to her is a problem. All right. Yes.
The STGM order, my lord.
Yes.
First order.
Yes.
Finding, my lord. Finding.
Yes.
Page 8.
Right.
Page 8.
Yes.
PW1 shows that about 9 years back, she married to the OP as per caste.
So you know the only solution to this is to settle the matter. You will not do it. You have not reached that litigation fatigue. One fine day, your client will reach that fatigue. Then he will settle. Otherwise, go on fighting like this. Yes.
In this regard, the evidence of PW2 and 3 goes to indicate that petitioner now were married to the OP as per 10 years back.
Yes.
Previously, he has said 125 CRPC, the petitioner has to prove he is married to wife of OP in this regard testimony period. So that about 9 years back. One says 9 years back and again says 10 years back. No date has been given.
Yes.
And in the issue number 3, my paragraph 8.
Yes.
Nothing indicated about the widow pension. Yes. Neither we have filed any document in the lower court, nor she has laid any evidence, not be corroborated by anybody else. The learned court not specifically stated about the widow pension is getting. She is getting. And the your lordship may kindly see page 9 also.
Yes.
Page 9 upper portion, my lord.
Yes.
On the other OP who is the co-villager.
Right.
I am saying that co-villager has stated have to know her. He has further stated to have not married her and PW2 is not his son. And in Anganwadi record, my lord, the father of name is also Khabeswar Kaun. That is my case.
That's it, sir.
Yes.
All right. Dismissed. All these things are dismissed. I'll pass the detailed draft.
Yes, sir.
The RF, RP, FAM, and these CRLMs.
Okay. Item number 5.
The case I am filing for costing of the FIR.
Yes.
FIR is lost against me. I am filing for costing of the FIR. FIR is lost against me by the father of the victim to whom I got married. And during course of the period, one habeas corpus has been filed, which is come along with this rate application, along with this CRLMC case matter.
Yes.
In the said habeas corpus, Honorable Court has been directed to produce the victim and record her statement, which has been recorded before the registry. And accordingly to the counter has been filed by the police. And nowhere it has been stated that I have been kidnapped the girl. That is the case, my lord.
No, what has she said in her 164? What has she said?
The judgment of the Honorable Apex Court regarding this aspect kindly tells, my lord.
May I be pardoned,
The
your
order
lordship?
passed by the Honorable Division Bench in WPCRL, criminal in habeas corpus, the victim's statement has been recorded. That has been reflected in the order.
As per statement, she states that she is 18 years above, but to the WPCRL, your lordship, habeas corpus, I have annexed at page 30 in the Board of Secondary Education examination admit card, where the date of birth of the victim is 18th January 2000, your lordship. To that, her age stands around 17, your lordship, on the date of occurrence. So she was a minor on the date of occurrence, and the present petitioner.
Whom are you for?
I am for the informant father, your lordship.
What has happened to the girl now?
She is married and she is staying with the husband, your lordship.
No, with you?
My lord.
Oh, I see. Why are you still pressing the matter?
I don't. His father is not. It is not in dispute that.
My lord, kindly peruse the statement. What she stated before the judicial.
It's all right. It's all right. It's not in dispute that the girl, having attained majority, has married the petitioner of her own free will.
Blessed with the child, man.
And they are now blessed with the child. In that view, the matter, you take the prayer clause and all proceedings consequent thereto hereby quashed. In the writ petition criminal, you say placed before the division bench.
No, that has been order passed by the Honorable Single Judge that become the infractions.
That has become infractions because she has attended majority.
So that's already over.
My lord.
Not disposed of, but that is still pending, your lordship.
That's what I'm saying. The formal order will have to be passed. You say for passing the formal order, you just have to place it before the division bench. I can't pass an order.
Lordship may kindly record my I have opposed that.
You say okay. Although the right in the beginning you say although the informant father still opposes it, the fact remains that.
Item number 6. Item 6.
None appears dismissed.
Item 7.
Same order.
May I please, lordship? Item number 7, I am appearing, my lords.
Yes.
My lord, petitioner who is army personnel having a very blemish-free career, my lord, and he has become a victim of a false case, my lord. Petitioner challenges that order dated 6/4/2009, my lord, thereby taking cognizance under section 25 Act, my lord. Background of the case is that brother of the present petitioner is inside custody. Present petitioner had been to jail premises to supply of his dress material. It is alleged that he supplied a polythene bag, and subsequently jail authority found one bullet was recovered from that bag in question, my lord. Subsequently they found one, for which they have specifically stated in the first information report, my lord. The person in doubt has been detained in jail.
Charge sheet filed.
Steps may kindly be taken investigation.
Charge sheet has been filed, sir. You can raise this.
Charge sheet has been filed, my lord.
Yeah, you can raise this, please, sir. Permitting the petitioner to raise all, please, at the appropriate stage. The petition is dismissed.
Your lordship only observed that forensic report negative such allegation. And
What is it? That you can argue.
Forensic report aspect, your lordship only observed that.
No,
aspect
everything, all your pleas you can urge. All pleas can be urged. All right.
Item 8.
Yes,
8, my lord. In fact, the quashing of the vigilance proceeding has been sought for in the case. By order dated 29 of January 2021, the Learned Council appointed for the vigilance was directed to take instruction on the matter. Thereafter,
For what? Instruction for what?
What is the stage of investigation?
It's all right, sir. Permitting the petitioner to take all pleas at the appropriate stage. The petition is dismissed. Right.
Item 9. To my knowledge, my lord, the investigation is over, but no charge sheet has been submitted.
So please stay peacefully, sir. Don't unnecessarily invite. I can ask them to immediately file the charge sheet. All right.
Item 9. Let it be permitted to be withdrawn.
Dismissed is withdrawn.
My lords, the Passover matter I have mistakenly appeared for the ARBP.
Don't be so careless, sir. And you walk in without papers. What is all this going on?
Please may be permitted to withdraw.
We don't even know whether you are there or not. You just say none appears dismissed. You have a wakalat number for this matter?
No, sir.
Then it's okay. None appears dismissed. Yes.
Again, none appears dismissed. Yeah.
Item 10.
None appears dismissed.
Item 11.
Item 11, I'm in VC, my lord. Unfortunately, today I'm in Hyderabad and the file is not with me. Can it come
Oh, no,
next
that's,
week?
no. It's all too much, sir.
No,
Mr. Acharya. No.
I just came yesterday, my lord. I'll
That's
just,
all
I'll,
right.
I'll just tell the background of the case. Then whatever I remember, I can just tell that.
Tell me.
Here, what has happened in 2003, one FIR was lodged under the Prevention of Corruption Act.
Yes.
And in 2006, the
Yes.
final report was given.
Right.
And thereafter, till 2011, nothing happened. And in 2011, the Vigilance Court at Cuttack, it asked for obtaining sanctions. Because
Yes.
they are all gazetted and administrative officers of this state government, my lord.
Right.
Thereafter, from 2011 till 2019, again nothing happens. Thereafter, all of a sudden, the matter was transferred to the Vigilance Court at Angul, and it, without taking the cognizance, summons were issued. And against that, we came to this honorable court, and we filed 2 separate CRLMCs. Rather, 4 CRLMCs were filed. The total 4 accused persons were there. Those CRLMCs were allowed. And thereafter, what happened again, after the CRLMCs were allowed, 2 were totally allowed. And as far 2 other matters are concerned, that is these 2 matters, the Vigilance Court at Angul again has asked for the sanction. So this is the point, because I don't have that order copy with me right now. Otherwise, I could have placed whether this second proceeding would arise or not, my lord. I am just telling out of my memory because I don't have the brief with me, my lord.
No. See, it is squashed only because of process is issued without taking cognizance. I think now cognizance has been taken. Now cognizance has been taken. The impugned order.
Cognizance has not been taken because the sanction is yet to be obtained, my lord. Because I am a serving officer. I'm in the cadre of Principal Chief Conservator of Forest, my lord. Sanction is yet to be obtained.
The senior counsel petitioner states that sanction is yet to be obtained, and therefore cognizance could not have been taken. What is the position?
The position is that, madam, thing is that in this case, sanction was initially final report was submitted. Thereafter that was not accepted. Sanction was sought for.
Has sanction been granted? He's saying sanction is still not granted.
Sanction has not yet been
granted. Then how are you proceeding the matter then? Is there a stay granted here?
No, my lord. No, my lord.
Counsel for the state will seek instructions on the current status on this issue. List before the roster bench on 28 June.
Obliged, my lord. The connected matter also same, my lord.
All right.
Permitted to withdraw.
Dismissed is withdrawn.
Item 13.
None appears dismissed.
Item number 14.
Permitted to raise all the points in the.
All right. Permitting the
But at the meantime, petition number 1 is already died, man. Petition number 1.
There's only one petitioner here shown?
No, there are 3 petitions.
All right. It says petition number 1 is stated to have expired, permitting the other petitioners to raise all pleas at the appropriate stage.
Item number 15.
Lord, sir. The present petitioners have filed this for the quashment of the very proceeding initiated as CT case number 1949 of 2022 pending before SDCM Jajpur. My lords, the informant had lodged this FIR alleging that they have threatened him of dire consequences. My lords, the present petitioner's niece, that is the wife of the complainant, and let's informant, they have some matrimonial disputes arising out of which there were some discrepancies for which he has lodged this affair against this present petitioners, my lords. Man, the present petitioner cannot take he says that to take back his wife and to let her stay in the petitioner's house. But the petitioner says that he doesn't have any much financial conditions to maintain her. So that's why he's saying that I cannot take.
That's all right. Permitting the petitioner to raise all pleas at the appropriate
I would say the notice is issued, the matter may be settled.
No.
Right. Item number 16.
Obliged, Lordship.
Pardon, my lord.
I'm in the VC, my lord. My lord, I have challenged the order dated 3rd April 2023 under Annex 3. So wherein
What is the offense, sir?
My lord.
What is the offense?
This is an 138 Negotiable Instrument Act. My 205 petition has been rejected. Therefore, I seek that I may be allowed to dispensing with my personal appearance.
All right.
And
where are you located?
My lord, the order is at the impugned order is at page number 25.
No, where are you located?
I'm from Bhubaneswar.
No, not lawyer, sir. Your client. You're representing a person.
Bhubaneswar.
He's in Bhubaneswar. So what's your difficulty in appearing?
Appearing in Baleshwar.
No one. Baleshwar is some 3 or 4 hours away. By road.
My lord, he is busy in business, small business for his livelihood.
Look at the number of occasions, sir. Since 2017, lingering for your appearance.
So, my lord, I have attached the entire order sheet.
It's only 7 July now, sir. You can easily appear. There's no merit in the present petition. You want to withdraw it, we can withdraw.
My lord,
the court has perused the order dated 3rd April 2023 passed by the SDJ in Baleshwar. The court finds absolutely no grounds made out for interference, particularly since the petitioner has been avoiding appearing in that court since 7 September 2017.
My lord, I may be allowed to withdraw, my lord.
Dismissed as withdrawn. All right. Put the prayer clause and say dismissed as withdrawn.
Item 17.
Your Lordship, the matter has been settled between the party. The way of the mutual divorce has been allowed between number 1, opposite number 2. George Femekar Bonsar. There is a clause that Lordship, all the matters.
Where is the wife's affidavit?
After it was come, Lordship. Opposite number 2, have a glance, Lordship.
Where is her affidavit, sir?
Plus pay affidavit Annex 3, Lordship.
Sir, where is her affidavit?
I will give me, Lordship. Annex 3, Lordship. Annex 3, page 24, Lordship.
That is their affidavit in the family code.
Your Lordship, after it was come, Lordship. After today,
you have to produce the affidavit here, sir.
Lordship, let it come any other day.
At the request of counsel of the petitioner, who needs time to produce the affidavit of the opposite party number 2.
Lordship, notice me should
list. You want notice to issue?
Notice, Lordship.
All right. You say notice he accepts for opposite party number 1. Notice to opposite party number 2 be served through registered speed post, returnable on the next date. List on 3rd July before the roster patch. All right.
Your Lordship. Your Lordship. Item 13, Your Lordship. Kindly, I'm very sorry, Your Lordship. Kindly, may liberty be granted. Item 13, Your Lordship, to raise all the points at the appropriate stage, Your Lordship. Very sorry.
Right. 13 is permitting the petitioner. All right.
Oblige, Your Lordship.
Item 18. Please, Your Lordship. So, my lord, the petitioner has released an interim bail for my lord surgery. My lord, during the surgery, my child bedridden and unable to surrender during the prescribed time. My limited grievance.
NDPS, sir. No question.
And liberty given to surrender. Only liberty.
No question, sir. No question.
Only.
Sorry, sir.
I'll surrender to the approach before the court below.
No question, sir. No question.
Surrender before the court.
No question, sir.
Only
you surrender. Nobody is stopping you from surrendering.
Only that.
No question. What do you want to do?
We do to approach before the court below. Only that. Liberty to approach.
No liberty. No liberty.
Only we do to approach before the court.
No. The court finds that this is an offence under the NDPS Act, and despite the expiry of the period of interim bail, the petitioner did not surrender. Consequently, the court is not inclined to grant the relief prayed for. The petition is dismissed.
Item number 19.
Lordship, Mr. Patnaik is out of station. He is an accommodation, Lordship. Taken up to any date of the next day.
What's the matter about, sir?
138 NIA.
Is there a settlement between the parties?
He is an accommodation.
What is accommodation? Nothing accommodation.
You have matter in the High Court, you can't just go away somewhere else, sir. Sorry.
205 application has been
No,
rejected.
no. Permitting the petitioner to raise all pleas at the appropriate stage. The petition is disposed of. Put down his name.
Item number 20.
None appears dismissed.
Item 21.
May I please have permitted to raise all the points in court.
Permitting the petitioner to raise all pleas.
Item 22.
None appears dismissed.
Item 23.
Same order.
Item 24.
May I please, Your Lordship? Your Lordship, I pray for withdrawal of the petition as in the meantime the trial has already been completed and we are awaiting judgment.
All right. Dismiss this withdrawal. Right.
Obliged.
Item 25.
None appears dismissed.
Item number 26.
And the petitioner has already expired in the meantime.
All right. The petition has expired. Dismissed as awaited. All right.
Item number 27.
The matter becomes infructuous.
Infructuous dismissed.
28.
None appears dismissed.
29.
Same order.
Item number 30.
In this case, I am for the petitioner, my lord. Notice issued to the opposite party. Return unserved due to address not found. Paper another step, my lord.
What is the matter about, sir?
Matter, my lord, we are challenging the framing of charge, my lord. Offense under section framing of charge order dated 18/3/2020 annexure 1, my lord. Offense under
340 Act, sir. No question.
341, 295, 294, 497, 506 of Indian Penal Code and 3 SC Act, my lord. Offense under 397, my lord. Can you see, my lord? The president is not a consenting party. He is the present informant, my lord. Can you see the 397, 497, 497 offense, my lord? She lost the FR, the aggrieved party is her husband. Aggrieved party is her husband, my lord. Can you see offense 497? Indian Penal Code 497, my lord. Adultery. Whoever has sexual intercourse with a person who is and who.
So 497 anyway no longer.
Yes, my
So
yes,
you consider the SC/ST Act, sir, now.
Yes,
Why are you
sir.
going to 497? After Joseph Shine, there's no Mr. 497.
Yes,
Come to
she is the
SC/ST Act.
consenting party.
So you come to the SC/ST Act, sir.
Yes,
How do you get over that?
3 SC Act also not made out, my lord.
You can't simply argue like that, sir.
She's
Charging
since long, keeping relationship 4 years since long, my lord.
All right.
Knowing your, my lord, in my ground number 3, my lord, can you see in ground number page 5?
Yes.
Page 5, my lord. 497, my lord.
Yes.
Clearly mentioned a part of so 499 IPC concern is not at all agreed, but agreed by provision of 199 clause 2, my lord.
Yes.
The prosecution offense mentioned against 1. No court shall take cognizance offense 497 IPC except complainant. He sees the consenting party.
Why are you stuck on 497? That's over, sir. You're not aware of the judgment of the Supreme Court then. You're not aware of consenting party, my lord. You don't make, if I don't know how to explain to you.
Yes,
anyway, you're only on, you don't want to argue SC/ST Act.
Yeah. Yes.
All right. You see, the present petition challenges an order dated 18 March 2020, passed by the
Paper raised the point before the court below, my lord.
All right. Counsel, the petitioner seeks leave to withdraw the present petition with liberty to raise all pleas at the appropriate stage. Dismissed is withdrawn with liberty as paid for. All right.
Item 31.
None appears dismissed.
32.
Same order.
Item number 33.
Same order.
No, my lord, my lord, I pray for an adjournment. A special counsel has been engaged in this.
For what this? Let's see what this
OPID matter, my lord. Next week.
The 2020 matters, sir. No question.
Lords, may kindly pass over.
All right, pass over.
Item 34.
None appears dismissed.
Item number 35,
Same order.
36,
Seeking for quashing of the FIR matter. The case is a counter case. Except 506, all the offences are available. Annex of 3 is the compromised petitioner file matter. The matter has been settled between both the parties.
Handwritten, sir. That you can point out to the trial court. Permitting the petitioner to raise all please. All right.
item 37,
None appears dismissed.
38,
Same order.
39,
Same order.
item number 40,
Same order.
item 41,
no instruction, madam.
No instructions dismissed.
item number 42,
Lord, this is the case for quashing of FIR. The petitioner accused was an SI of police, and the complaint against him is that on the 6th of February 2020, one complainant named Lakshman Tanti went to the police station Jaipur Sadar and presented a written report to the effect that an earlier FIR was lodged on the 24th of December 2019 about an accident wherein his nephew Devendra Tanti sustained head injury and then he succumbed to death in the CHC hospital, Rabanaguda. After some days, the complainant had been to Ambaguda police station to get his accident involved, that the vehicle was seized as alleged by the OP Malord. The vehicle belonged to one person named Ganesh Tanti, page number 21 of the annexure. And as per the allegation, on the 18th of January 2020,
demanded a bribe, sir. Why are you beating around the bush?
I'm sorry, sir.
So the allegation is that you demanded a bribe.
Yes, on the 18th of January. But however, for the recovery of the bike.
Right.
But however, on record, the bike has already been given to the complainant before the date of occurrence, alleged occurrence.
All that will be looked into, sir, by the court. Permitting the petitioner to
The
raise all
Chimanama
pleas.
is already there in there.
It's all right. You can point it out to the court. Permitting the petitioner to raise all pleas at the appropriate stage. All right.
item 43,
None appears dismissed.
44,
Same order.
item 45,
Permitted to withdraw.
Dismisses withdrawn. All right.
item number 46,
May I please, your lordship? Lordship, now the petitioner filed this petition for quashing of FIR, lordship, and in the meantime, after the order of in WPSRL 4140 of 2022, your lordship, there is a chance of compromise between both the parties, your lordship.
That's all right.
May I please, your lordship? Lordship, I'm appearing for the opposite party number 2. The joint affidavit will be filed, lordship.
All right. Both parties state that the joint affidavit will be filed before the next date. This before the roster bench on 5th July. All right.
Oblige, your lordship.
item 47,
None appears dismissed.
My lord, same, your lordship, as 46, your lordship.
46 is over, madam. 47 now.
Yes, your lordship. So same 46, 47 is same as the 46, your lordship.
All right. Same. All right. All right.
Yes, your lordship.
item 48,
Permitted to raise all these grounds.
All right. Permitting the petition to raise all please.
item 49,
None appears dismissed.
item 50,
Some defects are the one with time to remove the defect.
No, no. Tell me what the matter is about.
My matter is that my petitioner got married to the OP number 2, my lord, and thereafter they are staying for some days. Subsequently, OP number 2 came to her parents' house. Thereafter, she got married to another person. So, my lord, I have given the marriage photograph. I have allegations.
All that you can raise at the appropriate stage. Permitting the petitioner to raise all pleas at the appropriate stage. All right.
item 51,
On behalf of Mr. Das, not present.
Dismisses not pressed.
item 52,
May I please, your lordship? The state is the petitioner, my lord. It has been challenged. The impugned order is annexure 2, your lordship may kindly see. Annexure 4 at page 21, your lordship may kindly see. that the even if the confiscation proceeding was pending before the authorized officer, my lord, the criminal court having no jurisdiction has entertained the application under section 457 and was pleased to release the vehicle, my lord, in favor of the owner of the vehicle, my lord.
When was this order passed, sir?
My lord, this order was passed. My lord, my lord, the order was passed in 23/8/22, my lord. I have taken instruction yesterday, my lord. The vehicle is also with the department, my lord. That has not been.
What is the vehicle? It's a lorry.
My lord.
What is this vehicle?
A truck, my lord. My lord, your lordship may kindly see 56 subsection 3 of section 56, my lord. When the proceeding is pending before the authorized officer, my lord, the criminal court has no jurisdiction to release the vehicle, my lord. Your lordship may kindly see.
No, but you've not initiated confiscation proceedings. That's
Yes,
the whole
my lord. Yes, my lord. That has been initiated. Your lordship may kindly see that ground has been taken in the revision petition. Your lordship may kindly see at page 22. Your lordship may kindly see. Page 22, running page 22. Although a confiscation proceeding has been initiated under section 56 of Orissa Forest Act, by confiscation proceeding number 5 of 20.
All right. Counsel, the petitioner states that confiscation proceedings were indeed initiated, and therefore the impugned order requires to be interfered with. Notice returnable 22nd June before the roster bench. All right.
Hello. Stay up.
There's no need, sir. You're not anywhere releasing the vehicle. Let's see. Yes.
Item 53.
None appears dismissed.
Item number 54.
Same order.
55.
55, Your Lordship, on behalf of Mr. Swine, he is hospitalized. He is met with a severe accident.
All right. The counsel of the petitioner stated to be unwell. List on 6th July.
Obliged.
56.
Mrs. Father hospitalized in
All right. Same order, 6th July. All right.
Obliged.
67.
57.
57. I'm sorry. 57.
The informant has already appeared and filed his affidavit. The matter has been compromised. We have to file an affidavit to that effect. Your lordship kindly urgent the matter.
For the opposite partner to informant, I have already filed
affidavit.
Affidavit.
All right. Counsel for the opposite party. What is the offense, sir?
Constituted under section 354B.
All right. Counsel for the opposite party number 2 confirms the affidavit filed and states that the parties have settled their disputes, and she does not wish to proceed in the matter. In that view, the matter take from the prayer clause and all proceedings consequent thereto hereby quashed.
I'm grateful, Your Lordship.
Not 58.
None appears dismissed.
59.
59, my lord, taken up 1 week after because some defect has been pointed out by SR. Only my lord, my prayer is for discharge petition, which is also there, that has been rejected. Discharge petition.
List on 16th May, defects be cured in the meantime.
Obliged, my lord.
Item number 60.
My lord, matter has already been settled amicably, and the informant appears, filed the affidavit before this honorable court. That is also in the text. Your lordship will see in the cause list. Flag A. Matter has amicably settled, and counsel.
All right. Counsel appearing for what's the offense?
Offense 420.
All right. Counsel for the opposite party confirms the affidavit filed and states that the parties have settled their disputes and she does not wish to proceed in the matter. In that fifth matter, takes the prayer clause and all proceedings consequent thereto hereby quashed.
61.
None appears dismissed.
From 62.
Same order.
63.
Permitted to resolve.
Yeah, permitting the petition.
Obliged. 64.
The prayer for question of the convenience, taken section 15 of Environmental Pollution Control Act, my lords. Now, what has happened, my lords? In the meantime, I was told today that same similar has been quashed by the Honorable Court by coordinated bench, my lords. Say section 15 of EP Act, Environmental Protection Act.
Section 15 of the
Environment Protection Act. Environment Protection Act.
Where is that order?
Bhagavati, without obtaining environment clearance under the EP Act, I was running the mines, my lords. So, after common cause case, my lords, I have paid penalty also. Basing on that, the Honorable Judge, Mr. Sasikan Mr. has quashed the proceeding.
There is an order, sir.
Well, I could get it, will obtain. Next year, I will obtain it.
At the request of counsel for the petitioner. This for the roster bench on 16th May. All right.
Item number 65.
Good.
None appears.
66. 65.
My pleasure.
65.
In this case, the sister has filed this case, filed one civil suit and a complaint case. And taking the receipt for issuance of notice in the civil suit, he has convinced the lower court that the notice has been issued on the present petitioners in the complaint case. And for which the NVD was issued and they were arrested. And a false case has been filed only to grab the property.
It's all right. Permitting the petitioner to take all pleas at the appropriate stage. The petition is dismissed. All right.
66.
None appears dismissed.
67.
Same order.
68.
My lord, item 68 on behalf of my learned senior Mr. Gautam Misra. My lord, he is not well today.
What's the matter about, sir?
My lord, this is a matter. The present company is a, my lord, petitioner is a shipping company, and here, my lord, the present case arises out of a complaint case filed by Labor Enforcement Officer for alleged violation of Payment of Wages Act.
All right. Mr. Counsel for the senior counsel for the petitioner stated to be unwell. List on 12th July.
I am appearing for opposite party in this case.
All right.
Item number 69.
This case for the passing of criminal proceeding, the matter is arising out of matrimonial dispute. Divorce has been allowed. Both parties are living separately, and permanent alignment has already been received. And
who is appearing for the wife? Somebody is to appear for the wife, sir.
Annex 5 is wife has executed
no affidavit. Has anyone appeared for the wife here? Fresh steps. ED returned after valid service. Oh, all right. It appears that despite service of notice, none is appearing on behalf of the respondent but two wife. Counsel of the petitioner states that divorce has already been granted by the judgment dated 30th June 2014 of the Family Court Cuttack, which has become final, and the parties are living separately. Paragraph. That leaves the matter. Take from the prayer clause and all proceedings consequent that which you quashed. All right.
Item number 70.
Pardon, my lord. Item number 68, my lord, interim order to continue.
All right, interim order.
Item 70.
None appears dismissed. It's all right, so let's finish. None appears dismissed.
No instructions, my lord.
No instructions dismissed.
Item 72.
72, my lord, the number petitioner 1 is died. Let it come next week. I will file.
Not necessary, sir.
Petitioner 1 is died, my lord.
The others can raise the plea, sir. Petition number 1 is stated of dead. The other petitioners are permitted to raise all pleas at the appropriate stage. All right.
Item 73.
Let come next week, my lord.
For what, sir? No.
You
are in 73.
No, 72, my lord.
It's all right. 72 permitting you to raise all pleas at the appropriate stage.
No, my lord. There's a case, my lord. If cognizance taken under section 7 of the Essential Commodity Act, my lord.
Right.
Under section 6, a proceeding was initiated for confiscation. The allegation was suppressed, my lord. The commissioner government, my lord, while arguing, deciding the case under section 6, they found there is no suppress at all, my lord.
It's all right. So you can trace all these pleas at the appropriate stage. Sorry. Yes.
Item 73.
None appears dismissed.
74.
Same order.
74.
I am permitted to
raise all pleas. All right. All right.
75.
Permitted to withdraw.
All right. Dismiss is withdrawn.
I am
76.
appearing for OP, my lord.
All right, all right.
Item 76, my lord, petitioner be permitted to raise all the points.
Correct. Permitting to raise all case.
77.
Sir, my lord, it's a defamation case arising out of a crime.
We'll have it on some other day.
Yes, ma'am.
It's a list on 24 July.
Interim
For
order
the
to
rest,
continue.
interim order to continue.
Obliged.
78.
All the points raised before the
Yeah,
trial.
permitting the petitioner.
79.
Raise all the points.
Right.
79, I am for the opposite party, my lord.
All
My
right.
lord, proceeding may be targeted.
It's all right. That you can
NI
do
Act,
that.
my lord.
You can do that. Sir. Yeah.
Item number 80.
None appears dismissed.
Item 81.
Matter has been already compromised. The informant already appeared and filed.
Yes, my lord. I am appealing for the informant, my lord. I have also filed
Counsel for the
affidavit.
informant confirms that the parties have settled their disputes. The affidavit is also on record. That view of the matter taken from the prayer clause and all proceedings consequent thereto hereby quashed.
82.
My lord, I am challenging the order taking cognizance on the ground of compromise. Here, my lord, both the parties, that is the petitioner and the OP number 2, they were now serving in one company at Bangalore, your lordship. And matter is already amicably settled.
To get the affidavit, sir.
Yes, your lordship. For the said affidavit, earlier this honorable court has directed, granted us interim order and notice were issued. Notice was sufficient. Thereafter, instruction I have taken, they will file a joint affidavit and they will appear before this
All
honorable
right.
court.
At the request of counsel, the petitioner who states that a joint affidavit will be filed. This before the roster bench on 25th July.
Item 83.
Obliged, my lord. Lordship, interim order was there.
Interim order to continue.
Obliged.
83.
Similar, raise all the points during.
Permitting the petitioner to raise all these.
Item 84.
Here, my lord, the order passed by the London Additional Sessions Judge in the Criminal Division, that is under challenge, that is order dated 38/2019.
All right. List before the roster bench on 14th August. All right.
Obliged.
Item
Interim
85.
order to continue.
Yeah, interim order to continue.
Item 85, all the points raised before the trial.
All right.
86.
Arising out of the complaint case. And this affair, this petition for quashing the affair, this affair is not maintainable against me in view of section 305 of CRPC, my lord. Because I am the case is filed against the company, whereas I am not a party, but they have made all the allegations against me. Although they admittedly the entire rights and whatever through the market.
Where is the informant? Who's informant?
Informant is market.
You not made them a party, sir.
Market is made party.
When?
It is the state government. Now it is a affair lost. They have lost the affair. So
All right.
in view of
All
complaint
right.
case.
List
and it
before the
is-
roster bench on 9th August. All right. Interim order to continue.
Item 87.
87 matter it is a petty issue between Panchayat Samiti members and bank employee, and case counter case matter has been settled. Opposite party has
Counsel
also
for the
appeared.
opposite party confirms that compromise has been entered into between the parties. Take from the prayer clause and all proceedings consequent thereto hereby quashed.
88.
None appears dismissed.
Item 89.
None appears dismissed.
Item number 90.
None appears dismissed.
Last two matter, item 33.
My lord, in item 33, OPID is the petitioner, constitutor, and this case, Mr. B.N. Huya, he has been.
All right. At the request of counsel for the.
May I request your lordship to indicate the name of Mr. B.N. Huya
All
for
right.
the
The
petition?
name of Mr. P.N. Buam be indicated.
B.N.
Whatever, sir. All right. Be indicated for the petitioner. List before the roster bench on 24 July. This is Rautre. SK sir. Namaskar, sir.
Supplementary list for orders, item number 1, CRLA 186 of 2015.
There are 4 appellants before your lordship. They have been convicted under section 302. They have been inside custody since 2012, your lordship.
All right. Yeah. All right. It is pointed out that the 4 appellants have been in custody for more than 10 years.
More than 10 years.
And there's no prospect of the present appeal being listed in the immediate future. Relying on the judgment in Singada Singh, the court directs that during the pendency of the appeal, the appellants be enlarged and subject to the satisfaction of the trial court.
Obliged.
Right.
Paper book may be printed.
Paper books be readied and supplied to the parties within 8 weeks. The matter to be included in the list of final hearing thereafter. Namaskar, sir. Namaskar.
For orders item number 1, CRLA 204 of 2015.
Prepare for bail of appellant number 1 minus. He is in custody since 22nd July 2011, more than 10 years. And other two co-accused already
All
been
right.
released on bail.
It is pointed out that appellant number 1 has been in custody for more than 10 years now. The other two co-accused have already been enlarged on bail. There is no prospect of the present appeal being listed in its normal course in the immediate future. Relying on the judgment in Singada Singh, the court directs that the appellant number 1 be enlarged on bail during the pendency of the present appeal, subject to the satisfaction of the trial court.
Item number 2.
2 and 3 were dismissible before. In fact, I was in Delhi, my colleague suffered a heat stroke on that day. So the
main writ petition, does it survive, sir?
Yes.
The main writ petition, does it survive?
Yes, my lord. This is against order of the tribunal, my lords.
All right. For the reason stated, the order is recalled. The CM appeals are allowed. The writ petition is restored to the file of the roster bench and will be listed for hearing on. You have to pass a separate order in the writ petitions.
Yeah.
Same item 3, my lords.
Yes, yes.
Obliged.
Let's go for the roster bench on 17 July.
Obliged.
All right.
For to mention this is here not CNPL.
All right. It's recalled again, list before the roster bench. No, 1 minute, sir. We're still in the midst of
item number 4.
Who's in item 4?
Union of India.
All right. None appears dismissed. Oh, this you can mention it next Friday. Right.
Just there.
Pranam, sir. Pranam.
For orders item number 1, CRLA 735 of 2017.
735. My lord, petitioner appellant file for IA for bail, my lord.
Yes.
My lord, this case, the Honorable Trial Court, my lord, convicted 4 accused in same offense, my lord. Out of 4, my lord, 1 accused, Purnachandra Mohanto, is aged about near about 67 years, my lord. Now he is in very health is not well as per the instruction of the client, my lord. His health is not well, my lord. This case is totally, my lord, in doubt. This case is registered by the police, my lord.
How long has he been in custody, sir?
My lord.
For how many years has he remained in custody?
My lord, 7 years, my lord.
July 15.
You want to take instructions?
9 years, above 9 years, sorry.
July
my lord.
15, sir.
July 15, above 9 years, my lord.
Occurrence is on 10th July 2015.
Yes.
Custody minus
2000.
plus occurrence has taken place on 10th July 2015.
When was he arrested?
Was that, but that is not.
Next day.
Next day, my lord.
So he's been in custody for more than 8 years, almost 8 years.
There are several injuries which are, as you'll also find out from 7.
All right, there's no chance of the appeal being heard, sir. What about the other co-accused?
My lord.
What about the other co-accused, sir?
Other co-accused is the family member. All are family members.
They have been released.
No. Have they been enlarged on bail?
Yes.
Yes, my lord. During trial, they are allowed on bail, my lord.
No. In the appeal, sir.
No, my lord. They are not bail.
They are not released. My association.
So which of the appellants is applied now?
My lord, 4 are applied, my lord. My lord, a very serious condition is appellant number one, my lord. He is 67 years old now.
Appellant number 1 is 67 years old, he says.
Yes, yes, my lord. Health is not well.
Eyewitness case or
eyewitness?
Eyewitness, sir. It's
Eyewitness.
PW 47, sir. Come to page number, running page 23, sir. 11.
4713.
Running page 23, judgment, para 11.
In that case, we'll ask the paper books to be prepared, sir.
Yes.
Let the appeal be expedited. You can move, if it's really seriously ill, you can move for interim mail, sir.
Yes, my lord. He's
Again, number 858. You want to withdraw this and file it at an appropriate stage.
My lord.
You want to withdraw this application or you want us to dismiss it on merits?
My lord, I will withdraw, then file a better application, my lord.
The petitioner seeks leave to withdraw the present petition. This petition at the present stage.
My lord, I have withdrawn my petition.
The liberty to file a subsequent, an appropriate application at the subsequent stage. Disposed of is withdrawn with liberty is paid for. In the main appeal, we say paper books be prepared and supplied to the parties within 8 weeks to be included in the list of final hearing matters thereafter. Right, sir? Much. Which bench now? Namaskar, sir.
Pranam.
Pranam.
Orders item number 1, CMAPL 129 of 2023.
Lords, due to the sad demise of the earlier conducting counsel, no other name was appearing. So that's why the matter was dismissed for default. And the application has been filed. 12 days delay is there, for which section 5, we have also filed the limitation application.
All right. For the reasons stated there in the delay is condoned, this application is recalled. OGC number so and so is restored to the file of the roster bench, where it will be listed for hearing on 19 July.
My lord, interim order was there earlier.
Nothing is going to happen, sir. Anyway, the interim order to continue. All right.
Deep your time.
There's another matter.
Oh, CMAPL 279 of 2023.
May I please, Your Lordship?
Yes, please.
My lord, Your Lordship, may kindly see the order dated 11/1/21 passed in the writ petition.
Right.
Now, thereafter, my lord, so the matter appeared again on 26/4, and it was on the list thereafter, but did not reach. It suddenly came up in a special list, and we missed our name.
All right. All right. You see, the reason stated the application is allowed, and this order is recalled. This writ petition is restored to file. It will be listed before the roster bench on 27 July.
Delay may be completely application was also there.
Delay. All right.
My lord, the interim order will be restored.
Interim order to continue. All right.
Obliged.
Right.
pardon to mention, my lord, one matter has been dismissed by default by this one court. Well, I have filed an restoration application.
Maybe come next week.
Since very urgent, my lord, the already Tahsildar issued an eviction matter and fixed 9th of this month, my lord. Can be taken up 8th.
Can't sit for that only.
Well, I have attached that notice. The Tahsildar already applied for police deployment.
Saying for 9th. We always say that the restoration application is there. We can't sit, sir. We have a different combination.
At least 2 minutes. On 8 minutes. Well, since there is a direction for deployment of police by the Tahsildar Kunchi on 9th May.
Eight. All right. At 1:15, 1:10. All right.
For orders, item number 1.
Item number 1, my lord. I am appearing through VC, my lord. My lord, there's an application for extension of time for filing the representation before the excise commissioner, my lord. The petitioner in this case was suffering from COVID,
All right.
and my lord.
Time for filing the representation is extended till 1st June. All right.
My lord, the other three
Correspondingly,
matters.
the time for disposing it of will stand extended. All right.
Highly obliged. My lord, 2, 3, and 4 are similar matters, my lord.
All right. The applications are disposed of. All right.
Highly obliged.
1 to 4. Item number 5. Item number 5.
File a CMAPL. Apparently, there was another similar application before the other bench.
Yes.
Counsel for the petitioner seeks leave to withdraw this application with liberty to file a CMAPL in accordance with law. Dispose is withdrawn as liberty is prayed for.
Item number 6.
Your Lordship, may kindly look into the noting of.
Yeah. The correction be carried out as pointed out. All right.
Yes.
Item number 7.
I am appearing case number 7. Lord. We have filed this application seeking clarification in my lord's judgment passed on 15th March 2023, my lord. In my case, my lord, in fact, by the judgment, my lords have held that the sufficient cause as per section 7 subsection 5 of Orissa Entry Tax Act will be subsisting till the pendency of interim order and till the date of disposal by the Honorable Supreme Court. In my case, my lord, my matter got disposed of in.
Yes.
My matter got disposed of with William Fernandez, my lord, on 9th of October 2017. And after that, I paid remaining 2/3, my lord. So, my lord, and as far as the issue is concerned, my lord, it
amounts to review, Your Lordship. Your Lordship, only difference is that all the other cases.
I know. Earlier, this came later, a few months later.
Only that is the difference, but it will
the law. I think we remember clarifying it's a judgment in rem.
My lord, I have a different point, my lord. As far as matters arising out of Honorable Odisha High Courts are concerned, my lord, there were 3 batches before Honorable Supreme Court.
Whatever batches, it's all right.
My lord, in fact,
the 9-judge bench, it's all matters in rem. No specific.
No, but as far as the finding in my lord's judgment is concerned, it clearly says that the sufficient cause subsists till the time interim order is there. In my case, my lord, the interim order got subsumed in the final judgment the moment my matter got decided, my lord. I'll just show the interim orders, my lord, because in Reliance judgment, the interim order which was in
all your orders were consequential upon the larger bench judgment. They all got vacated following the larger bench. It so happened your matter got listed later, so your stay continued for a few months more.
Indeed,
otherwise, the law got settled.
No, my lord. In fact, there were not only my matter, my lord. There were so many other matters which got disposed of in these 3 different batches, my lord. And in fact, my lord, in subsequent interim order, or let's say the final order by the division bench of Honorable Supreme Court, there is a clear-cut noting wherein they say that
Sorry, sir, we don't agree with you.
My lord, if I may be allowed to make small submission, my lord, because in all these orders, my lord, the Honorable Supreme Court has noted not only the interim order dated 3rd of February 2010, my lord, but subsequently my own interim order, which followed the earlier interim order passed in Reliance, my lord. And basis that, my lord, my submission is that the sufficient cause was there, my lord.
All right. We have heard the learned counsel, the parties. We're not inclined to entertain the prayer made in the present application. The application is dismissed.
My lord, just small request, my lord. If I may be allowed 30 days time as it was given in earlier judgment, my lord.
No. Nothing more, sir. Sorry.
Item number 8. Sorry.
So right.
May please, Lord. Item number 8. Now here, under on 2/1/23, Lordships issued notice, but inadvertently interim order was passed, where I have not prayed for any interim order or I was not filed. But Lordships on 1st March, Lordship vacated the interim order, but the writ petition was disposed of. The writ petition is pending because there was file counter, I prayed for rejoinder. With regard to interim order, it is to be vacated, but the writ petition has been inadvertently disposed of.
What do you say?
We have filed counter affidavit.
Yes, I prayed for rejoinder on that day, on 1st March.
Lordship may fix it to any.
All right. The order is recalled. The application is allowed. The main writ petition is set today by the order passed in this IA. The present writ petition stands restored. See, rejoinder has already been filed by the petitioner.
No, Lord, I will file.
All right. Counsel, the petitioner states that he'll file rejoinder before the next date.
Yes.
The interim order passed earlier stands vacated. List on. Let's go to the roster bench on 23rd August.
Item number 9.
May I please, Lord? Lord, in this case, Lord, my main argument was that the portal is not allowing me to file separately, and that therefore I was obliged to file by taking all the 3 units together. It seems, Lord, the judgment has, Lord, at several places noted that undisputedly I filed it consciously, taking all 3 units together. This was the fulcrum of my argument, that the portal says that if I have 3 units, there are 3 fields which I have to fill, and I have to just fill it. Everything is done automatically, and that's what I submitted. That since it was not for me,
that is confined to your facts of that case.
Milords, in fact, Milords, may kindly
Because
have my
by way of supplementary refund application, you wanted to revise the original one.
Milords are right.
So here the authority had already considered your petition for refund application. Whatever you have filed, that was allowed.
Milords, may kindly
Thereafter supplementary, you have
the first one that I filed, I have no option. That is why we came to this honorable court. Milords, may kindly have para 5 of the judgment, then I show my pleading. It is undisputed. Just for a moment, Milords, may have para 5. Milords, judgment in para 5 says undisputedly, Milords, that is page 70 of my application, which is before my lords today. Milords, I had only 2 arguments. I had said portal doesn't allow me, and I showed several instances where it is not based upon formula. Both these things somewhere, Milords. Milords, may kindly have page 70.
Page 70?
Yes, Milords. Of this application.
Right.
Milords would have para 5 of my lord's order, Milord. Judgment.
Right. Undisputed fact.
Yes, Milord. The undisputed fact from the respective pleading transpired that the 3 units of petitioner, namely Lanjiga 2, MTPS so-and-so, Jharsuguda so-and-so, and Jharsuguda so-and-so, situated within the state of Odisha having single registration, claimed refund of unutilized input tax rate by computing the quantum taking transaction of these 3 units together. Now, Milords, may kindly see my pleading at para 11 of the writ that I had no other option. That's why I came to this honorable court. That was a very grievance. Milords, may have para 11, and that is undisputed.
So the portal did not allow you to
Yes, I had to just put those 3 figures. I had no other option. And I showed a Gujarat High Court judgment where the revenue itself stated that we can apply on the basis of input-output norms. And Milords, input-output norms are different for each unit. That somehow has escaped attention in the judgment also.
But
That
your prayer is something different.
Milords may kindly for a moment have para 11.
That
Milords,
will
can
not
I-
change the course of the judgment itself.
Milords may kindly have para 11. Milords, this is my basic argument. And at 3 places, Milords have recorded that I did it. It was not I who did it. It was
But
the
what is
court
my
who did
prayer?
not allow me.
You see what
Yes,
prayer?
Milords. For a moment, Milords may have para 11, then I'll come to prayer, Milords. For a moment, only for verification, Milords may see.
Yes.
Yes, Milords. Of the writ, Milords, page 10. And this was undisputed, Milords. That during the relevant period, the application for refund was to be filed on GSTN portal, which mandated that single application is to be filed for one registration for the relevant period. Thus, petitioner has no option but to file single application. That's why, Milords, I had to file separately for claiming what was extra, and for that I claim before my lords.
Say notice, who has accepted?
Yes, I myself.
All right. He accepts notice. List on. We'll have it after the vacations. 14 July.
Extra copy में can be.
All right.
I am deputy.
Your Lordship, pardon your Lordship, that item number 6 may be directed to be listed before rostered bench. That is the interim order correction.
All right.
Your Lordship.
Item number 10. Hey, please, Your Lordship. I appear for the review petition, Lordships.
Yes. Yes.
Lordship, we are no grievance on the ultimate merits, Your Lordship. In fact, we have paid back the tax also. Your Lordship dismissed the writ petition, rightly following the Supreme Court, and said the rule is retrospective has been upheld also.
Right.
But Your Lordship, I amended the writ petition, and Your Lordship allowed the amendment, and I had challenged the assessment order, adjudication order on other grounds also. Namely, it is without pecuniary jurisdiction, you're not appealed, etc. Your Lordship perhaps thought that since the validity is upheld, no other ground is there in the petition. That seems to be a small error, Lordship. Then we went to the Supreme Court. Supreme Court says, go back to the High Court. That's what. So our prayer would be, Lordships, let me be allowed to file an appeal before the appellate authority within a time Your Lordship specifies. I'll contest the matter on merits and other grounds, Your Lordship. The writ was initially filed against the validity of the rule. Subsequently, we amended it to challenge the adjudication order also. They are imposing penalty also, Your Lordship, in this case. 10% penalty, interest. So therefore,
all right, we'll just issue notice.
Yes.
You accept notice?
Yes. No, I received one copy. Let me give me extra copy.
All right, extra copies we served on him. We'll take it soon after the vacation, sir.
whatever. Whenever it's convenient, Your Lordship. It's my
All right.
pleasure, Your Lordship.
14 July. 14 July.
14 July.
All right.
Item 11.
My lords, may I please, Your Lordship, I'm appearing through video conferencing.
Yes.
My lords, here, unfortunately, the matter was dismissed for default because the matter was being handled by Justice Savitri Ratha after her elevation, my lords. There was some.
For the reasons stated, the application is allowed.
Yes.
The order is recalled.
My lords, deeply obliged.
It's before the roster bench on 24 July.
Deeply obliged.
Item 12. May I please, my lord? My lord, before I come to the prayer and the interim application, my lord, I'll just briefly demonstrate the manner in which the petitioner has been treated. My lord, I was an applicant for on-shop liquor license for the year 2022-23, my lord. My lord, my application was entered into by the inspector, my lord. Thereafter, he furnished his report to the collector. Collector in turn furnishes views to the commissioner. Commissioner, my lord, at that stage, instead of not.
So this is not an IAS, sir. This is again a fresh prayer for the whole thing.
Fresh call of action, Your Lordship. And there are several orders passed by Your Lordship in the last brief. And as it appears that the impugned order, nothing has been taken note of by the government, all the earlier orders. And he has rejected, the government has rejected. That is why the IA has been filed purportedly. But what I beg to submit, that in the previous occasions, Your Lordship has given many directions. This Honorable Court has given many directions and all the favorable recommendations are there. Still, the government has rejected the EA on the ground that is violation of Rule 26.
But no, we disposed of allowing a prayer, no?
Yes,
That
my
is
lord.
why, that is
My lord,
why,
your lordship, just kindly for a moment, the first order. My lord set aside the order of the commissioner, saying that the commissioner does not have the power under Rule 26 to remand back the matter to the collector.
That
And
is why
therefore,
the petitioner has
the commissioner was directed to furnish his views to the government, and the government in turn was supposed to take a decision. But what the government does at this stage,
what the government does, again, government, my lord, dehalts the rules, my lord, remands back the matter for a fresh look to the commissioner. Again, I approach this honorable court in another IA. At this stage, my lord, the learned counsel appearing for the state, he furnishes a report, a fresh letter of the commissioner saying that in between the commissioner has acted upon the collector's letter. But ultimately, my lord, I am not entitled to trade in liquor, my lord. It's not a fundamental right. But at least I have a right to be treated fairly, my lord. Your lordship,
Well, no, do you come through an IA like this?
no, because I'm just compelled to draw your lordship.
So already an IA we entertained on 24th March.
In fact, on the last IA, your lordship was about to issue contempt notice, but on the
You file a contempt, sir. You file a
My lord,
contempt.
what I beg to submit, that his allegation is that government has not taken care of the.
So you are agreeing to this prayer then?
No, I am not agreeing. But if your lordship will see that your lordship can direct the government to reconsider in view of the earlier orders, and recommendations. Because
I mean,
Whatever order they take, I'm not inclined to entertain this IAs.
Lord, may I only consider, I'll make a fresh representation, let them consider. my lord.
Or a counsel of the petitioner seeks leave to withdraw this IA with liberty to seek other appropriate remedies as may be available to him in
no,
accordance with.
but if your lordship will not give in the direction, we cannot entertain. Because there is an order of the government. If that order is standing, then no further representation. If your lordship will pass this order and again ask the petitioner to.
In IA, how can we?
No, because it is a continuation of the previous proceeding.
You want to say that you will consider this irrespective of the earlier orders?
Yes, yes.
All right. It is clarified that while considering the proposal of the petitioner in terms of the main judgment of this court, the earlier orders by the government which may be adverse to the petitioner will not be taken into account. All right.
And this order should not stand. This last order dated 29/4, which is that will not stand on the way, because unless that is quashed, we cannot.
Full stop. It is further clarified that the fresh consideration will be irrespective of the order dated 29th April 2023. All right.
Item 13. 13, yes. The state is the petitioner, my lord. Your lordship may remember, for non-filing of the counter affidavit.
The copy of the IA has not been solved on.
Just I'm saying, there is nothing to solve copy on them. It is between the court and the state. Your lordship has imposed 25,000. In all the cases, your lordship is imposing cost. If the counter affidavit is not filed within time, then 20. Here is a case, directly your lordship has said 25. Only after the order is passed, within 2 weeks, we have filed the counter affidavit. The date is 2 August.
Order was passed because on the 4 occasion, this honorable court has.
Already it is stated that now the counter affidavit has been filed,
but the copy has not been solved.
Counter affidavit copy is already solved.
Not on me.
Yes.
No.
Right now I'm sorry.
All right. In that view of the matter, the payment of costs is waived. The IA is allowed. All right.
Outlies.